Intellectual Property Office, representative of the university, Mr. Arnav Duggal, Project Associate, IPTSE Academy, ladies, gentlemen, and distinguished guests. Today, the world is facing an unprecedented crisis where almost all countries are struggling with the pandemic and the resulting economic pressures. Such crises often push us all for revisiting existing norms and notions, and sometimes even provoking thought processes for changing knowledge and power centers. The current pandemic situation has initiated changes in thinking patterns of various countries in terms of their power, resources, and innovation status. India too has shown up as one amongst the new world's leaders at various fronts, while many developed countries have failed to manage the worst pandemic situation. Efforts are on to find a treatment protocol and vaccine against the virus. Several drugs and treatment therapies are being tried and tested to find a cure for this pandemic. In the middle of this fervent R&D activity, some questions come to mind. What about intellectual property protection? Intellectual property rights, or IPRs, play a key role in every sector and have become the basis for crucial investment decisions. IPRs are exclusive rights, and therefore there is always a challenge to strike a balance between the interests of the innovators and the interests of the society at large. With the rapid globalization and opening up of the Indian economy, intellectual capital has become one of the key wealth drivers in the present international trade. International property rights have become significantly conspicuous on the legal horizon of India, both in terms of new statutes and judicial pronouncements. Indian statutes, enforcement provisions, and methods of dispute resolution with respect to intellectual property protection are now fully TRIPS compliant. India's obligations under the TRIPS agreement for protection of trademarks inter alia include protection to distinguishing marks, recognition of service marks, indefinite periodical renewal of registration, abolition of compulsory licensing of trademarks, etc. India has taken strong steps in strengthening the patent system in the country. The government aims at establishing a patent regime that is conducive to technological advances and is in line with global commitments. Patent application filing at Indian Patent Office has been increasing consistently over the years, which demonstrates the confidence of the global industry in the Indian patent ecosystem. Another important factor is having an adequate legal framework to protect the interests of innovators and inspire confidence that their intellectual property will be protected, in turn triggering further innovation. Realizing the importance of IPR as the key differentiator for industrial competitiveness, the Indian Chamber of Commerce has been engaged in generating awareness through its numerous conferences, seminars, and workshops such as this one today. With these few words, I once again welcome all our eminent guests and speakers and look forward to fruitful deliberations and interaction. Thank you.
Thank you, Mr. Singh, for such a lovely welcome address. And I'm happy to see Mr. Vikas Sharma here. We were unable to get through each other in the morning, but I'm so very happy to see Mr. Vikas Sharma here. Mr. Sharma, your microphone is on mute. So if you can just... So would request Mr. Vikas Sharma, who is the Deputy Controller of Patents and Designs from the Office of the Controller General, Patents, Designs and Trademarks, to give his special address. Please, Mr. Sharma.
So, good morning, everybody. And thank you, Dr. Singh, for giving this welcome address to us from behalf of Indian Chamber of Commerce. Am I audible, Rahul?
Yes, you are.
And actually, how many participants from the student sides are there? Because I like to, do in that fashion only.
There are 97 students as of now. We are expecting around 50 to 100 more.
And will they be comfortable in Hindi or English? We'll do it that fashion only because this is for them.
Yes, this is a special address. This you can be comfortable in English, Hindi both. You have another session, Mr. Sharma, from 12:15 onwards. That is the protecting IP rights and the registration procedures. That would be specifically for the students.
Yes, okay, fine. See, we all know that how this pandemic is affecting all of us, and even IP offices are also struggling. IP fraternity is also struggling. in a way that that courts were supposed to come into picture, that and they gave us this extension of limitation periods and all. But anyhow, we were doing our best, and in that best, what we observed actually, that we were doing more. We were doing more work rather than getting less work from the IP side. So even the government also decided that we'll now go and knock the doors of the public to the universities, to the, and that's why this sort of awareness program is one of the ICC, Indian Chamber of Commerce, CI, FICCI, and we are engaging all of these institutions, and we ourselves are also doing this awareness, and we are targeting almost 10 lakh people, 10 lakh students to be aware by this 15th March 2022. And by the way, we are again we have got a number of amendments in our patent act, keeping in mind that what are the public is expecting from us. We have reduced our fees, we have reduced our timelines. In fact, these all things I'll be covering in my seminar. But few things actually, just like because this is probably a program for agriculture university, and now even last day only I was just seeing one video from our fertilizer minister. What he was sharing, he shared that somebody got a patent in US for a fertilizer. Then he wrote an email. His father told him that person was probably from Gujarat, that why don't you ask and develop something for India. That fertilizer thing, that person wrote an email to our prime minister, then prime minister showed some interest. I mean, telling the story is not big deal, but the thing is that how serious government is towards innovation and all. Then they called him and they discussed the idea with him. Then ultimately what he did, he got a product which ultimately was selling we can say this 30 kg this, and now he's capable of selling that in 1 liter bottle. So that kind of fertilizer thing he's capable of developing, and that is being sold in India also. This was developed with IFCO and all. And so this is all, I mean, we are getting this. Today is Soils Day also, and what is soil actually? If I talk to UP people, they deal with this agriculture and all, and this is agriculture university product theme. And if we see that microorganisms in India, they are, flora and flora of India is incomparable to anywhere in the world, uncomparable to anywhere in the world. But the facts is we need to catch on these things. And again, I need to tell that this microorganisms occurring naturally in earth, they are not patentable, but if you do something, they are patentable, right? And if I talk to the patent office sort of thing, that what exactly we are doing, we have reduced fees for the startup, we have reduced fee for the, seeing all this eco culture of the country, what exactly is going to happen in this country. So we have reduced this fee structure for startup, and we have reduced their timeline so that we have introduced expedited examination. We have reduced fee for even now universities also. I'll come to this again when I talk to what is patent filing procedures in India. And in fact, we are waiting for more applications. Like I told you earlier, what we were doing more work in fact in these pandemic days. So we are expecting more work from the public side. And maybe many people will not like to hear the full day seminar because I'm talking in UP, and I know that how UP behaves. The UP, if you are not doing anything, not going to the court, they say you are not doing anything. So now, what exactly is this for patenting system in our courts? Now, IP code has been established. IPAB has been abolished by the government. Now, what is there in this? Now, IPAB is recognizing the patent agents as such its advocate. The persons who today may be attending today's session, they if they are students only and they are from science stream only, and they are not going to the law colleges and all, but still you have got a chance to represent your clients directly to the High Court, and it is a big deal for at least for the UP guys. And as for this, you need to be a patent agent, and for this, I need to tell you that we have now advertised this notification for becoming this patent agent for all of you. Anyone who is interested, they can register, they can apply, and they can become patent agent. This test is being conducted. I think December 21 is probably little time. By that time, you can apply for this. And maybe see, this is a strategical game. What you do in your patenting business, because I need to tell this to everybody that most of the persons, most of the examiners and the controllers like me who are sitting in the office, they have been trained in foreign offices also. So one instance I need to share with you that because many times we feel that there is nothing in my idea, but actually this is how a businessman is going to take you. One example I like to share that when we were in Japan, they told us one story that because our prime minister is also like, he doesn't drink. I mean, drink means liquor. So, but he takes tea. Okay. So now what one lady has developed, she has developed this tea, green tea. It's very common there, and ordinary it's sold for almost 100 yen thing. 100 yen bottles are kept there. Now, what was there in that particular innovation or this? That lady went to one patent agent. She told that this is my product. What we can do with this? Then that person told him that there's nothing great in this. This is only a tea sort of thing. But later on, they decided, okay, we'll go for protection for this. Before doing this, they did some random sampling and all. And now, what exactly they were able to do with that? They defined that this is a special taste which they need not to have a patent protection. They'll be going for this trade secret sort of thing. But ultimately, they were selling that in a million yen sort of thing. So now this is being shared with only when prime ministers of the country visit to that particular country. So I mean, this sort of thing is their patenting. It's not only one small idea. It can be anything. It's up to you how you are going to market and what is the market expectations from you. So, and with this, I think we can start with today's seminar with these concluding words. Okay, so I wish all the success to this conference today.
Thank you, Mr. Sharma, for the wonderful special address. We would be keen to hear your another session, which starts at 12:15. Thank you so much. And with this, I would request Ms. Sasha Dugal, who is a project associate with IPTSC Academy, to go ahead with the presentation on the 4th edition of IPTSC.
Good morning, everybody. Thank you, Mr. Chakravarti. I am going to be sharing my screen now. If you could just tell me when it is visible to you guys.
Yes, it is visible.
Okay, great. So, good morning, everybody. My name is Saisha, and I'm a project associate at IPTSC Academy, which is the first and one of its kind IQ Olympiad in India. And here I'm going to be taking you through a brief presentation on IPTSC about what IPTSC is about and what we do. So what really is IPTSC? IPTSC, or Intellectual Property Talent Search Examination, was launched in July 2018 and is the first and one of its kind annual IP Olympiad for intellectual property rights in India. This is an exam that certifies registrants for their knowledge in various facets of intellectual property, from copyrights to patents, trademarks, geographical indication, industrial design, trade secrets, and so much more. This exam was conceptualized and administered by IPTSC Academy and has received support from many organizations who believe in the knowledge economy and the role that IP plays in inclusive growth. Some of these include, and many of those people, representatives are sitting here: Ericsson, Indian Chamber of Commerce, AICTE, Ministry of MSME, Ministry of Information and Communication Technology, I have Gujarat, MIT Vice Startup, and several others. Now, why should you give an intellectual property Olympiad? How is that Olympiad going to help you, students, working professionals, whether it's university students or students, school students, everybody is eligible to give this exam. And the benefits of this exam, firstly, as I said, that it is the first and one of its kind IP Olympiad. You will not find exams that certify you on intellectual property otherwise in this country. And this exam is getting you recognition from government bodies and corporates. And this recognition definitely gives you a competitive advantage in your career shaping. When you go out there, when you go out in the world, whether you're a job seeker or you are a job creator, the fact that you have certification from such people, from such organizations and institutions is definitely a benefit in your resume as opposed to your counterparts who may not have this recognition. Cash prizes and scholarships. Winners of the IPTSC Olympiad also get chances to win exciting cash prizes as well as scholarships. So it's not just the certification you're getting, you're also getting monetary benefits, you're getting rewarded for the exam and the learning that you get. Learn. Besides excelling in intellectual property, IPTLC also has sub-programs where we can collaborate with school students, university students, working professionals, faculties, etc., into a learn and earn program, and also help them get this sort of monetary reward besides the cash prize. So you also get that extra chance to get some money and to win some money while working and collaborating with IPTSC. Internship opportunities. Many participants who get great score in IPTSC get a chance to intern with renowned corporates who are affiliated with us. So not only are you getting to work with IPTSC, you might also get a chance to work with a corporate affiliated with it, like but not limited to Ericsson. Here in such internships, you get the chance to interact with professionals in the domain of IP, to work in the realm of IP and know more about it. So I'm sure that that really is a benefit to many students who want to study IP in the future, or many students who are interested in learning about intellectual property. Comprehensive course material. To give the exam, we provide you with course material. So when you register for the exam, we provide you a plethora of course material, which is unique and interactive and created at a cost basis by our research scholars under the supervision of IP experts. So this course is made in a way where it's from basic to advanced level, and every student, every registrant, whether aware about IP or unaware about IP, will understand this course material in a great way and will learn something new about intellectual property. Professional guidance and mentorship. We, besides helping you study for IP, also provide you with professional guidance on how to reap monetary benefits of your creations and innovations globally. And this is a great opportunity to know about IP rights, not just in India, around the world. And so that if you are a creator of something, you will get to understand how to protect your creation worldwide, as well as how to monetize it. Why should you care about intellectual property? As Mr. Sharma said previously, we have a lot of university students here. How does IP help them? IP, firstly, as we've said, can be a unique selling proposition of the product or service in today's competitive and dynamic world. We already know that the government is reducing the cost for patent filing in universities today. And that is only a sign that IP is as influential today as it has ever been. And it is critical for fostering innovation. Without the protection of ideas, businesses and individuals would not reap the full benefits of their inventions. It is a study that students who have knowledge in IP on their resume get better job opportunities than those who don't. So the fact that giving this exam will provide you with that crucial IP knowledge can really take you long ways. If you're a job seeker, then towards good opportunities. If you're a job creator, then towards creating something that will help you reap monetary benefits of it around the world, that it will help you help other people through that creation. Now, how do you register for the exam? For instance, you want to go out there, you want to register for the intellectual property talent search examination. Our registrations are still open. You just have to visit our website, www.iptsc.com. There's a button called click on register now. You just register there. and enroll yourself for the 4th edition. Everybody from school students, high school students, university students, as well as working professionals and faculties, as well as startups, are all eligible to give this exam. There, you sign up your details and create your account. Once your account has been created, you get a chance to pick one of 2 plans. You can choose the plan that best suits you, and that is it. Your account is now being created. You can enjoy an exclusive variety of webinars, unique course material, mock tests, etc., which will all help you not just give the exam, but also improve your IP knowledge. Reading course material offered by IPTSC. As we said before, we are providing a comprehensive course material to our registrants, and this course material is made in a way that it covers almost all domains of IP that you will need. There are booklets on career and monetization using IP. We have study material on industrial application of competition law and IP. I'm sure that hearing this name might intimidate many of you, thinking, oh, this is about law, and students studying law might get an upper hand over students who are not from the law background, but that's not the case. We've created the exam in a way where you will compete only against those of your background. So working professionals against working professionals, startups against startups, and students and the specific domain that they come from will compete against the students of that domain. So you can be rest assured that there will not be such a problem. Then we have booklets on prior art searching. We have presentations on topics under IP, as well as industrial application of intellectual property laws. Awards. Perhaps this is the most interesting part of this exam. You get awards nationally, regionally, and across the different domains of students, across that spectrum. So for working professionals, for startups, for students, university students, school students. Our national champions get all India for rank 1, 2, and 3, get rupees 40,000, 25,000, and 10,000 respectively, with merit certificates and internship opportunities. We also give a cash prize of rupees 1,000 to our top 20 rank holders, and have a special section for regional champions. If we get a certain number of registrations from each region, the person who scores the highest marks in that region gets the award for regional champions, and its award is rupees 2,000 along with merit certificates. Careers that involve intellectual property. I'm sure that hearing all the experts who've come in to speak today will make you understand that intellectual property is not limited to just law students, to just lawyers and intellectual property professionals or patent agents. It goes beyond that, whether you're a designer, photographer, lawyer, researcher, painter, musician, writer, researcher, anything you may be, so long as you are referring to a product in this world, whether you're creating the product or you are using that product, you are related to intellectual property, and you must understand intellectual property. And once you go through all of these presentations, you realize that this is something very, very crucial to everybody today. The fact that you need to learn how to use the internet judiciously so that you are not infringing on someone else's intellectual property is just as important as someone else infringing on your intellectual property. And knowing about these rights today will allow you to become much more independent, much more smart, and aware in this world today. Now, the timeline for the 4th edition. This year is the 4th edition of our exam. Our registrations, as I said, have begun, will end on 12th December. So you have a couple of days. Those who want to register can register for the exam at our website now. We have a mock test for our students, and we don't have one date for the mock test. So 16 to 20th December is a range of dates, and we give a range of times as well. So you can choose your date and you can choose your time for when you want to give the mock test. Same applies for the main exam, 6th to 10th January next year. You can choose the date you want to give the exam. You can choose the time you want to give the exam, and you can do it accordingly. Then our results and award ceremony are going to be announced in 2022 next year. So it's next year. Now, how can you crack the exam? We have our YouTube channel where there's a load of free content, webinars, IP trivia. You can all explore all of that on our YouTube channel. Then we also have the course curriculum given on our website. As I said, you will only compete against those who are from the same domain. So you can go to our website and read the course curriculum to know what you will get in your exam if you have a certain specialization. Say you are a design student, what are you going to study then, and what are you going to be tested on as a design student or as an architecture student or a law student or an engineer or whatever that it is you're studying. Then read and study the booklets. As I said, if you read those booklets, it's not just about the exam, it is about IP knowledge that will remain with you for the rest of your life, that will benefit you for the rest of your life. Government and industry partners. As I've said, you get certification from so many people: AICTE, ICC, Department of Science and Technology, Inspire, Ericsson, MIT Y Startup Hub, NRDC, ICT Division, iHub, institutions, Innovation Council, and so many other people from the universities that are affiliated with us, from the people that are affiliated with us. And this is a great thing to have on your resume. And that is it. If you want more regular updates from IPTSC, you can follow our social media handles as given here. Our Instagram handle has a lot of free content, as does our YouTube, so you can have a look there. And as I said, if you want to register for the exam, you can visit our website, www.iptsc.com, to know more. Now, I'm just going to stop my share. And that is it. Thank you so much for hearing me out. Sir, you can take over now.
With this, I would request Dr. Prachi Bhargava, who is the Director, Institute of Agricultural Sciences and Technology, Sri Ram Swarup Memorial University, to please deliver the keynote address. Dr. Bhargava, please.
Thank you so much. Thank you, Mr. Rahul Chakravarti. To one and all, I hope I'm audible enough.
Yes, you are. Please.
Yeah, okay. So good morning to one and all. So it's a matter of pride for Institute of Agricultural Sciences and Technology, Sri Ram Swarup Memorial University, Barabanki, to conduct a webinar on IPR related issues in collaboration with the Indian Chamber of Commerce, Indian Patent Office, along with Ericsson India Private Limited, Motion Picture Association, and Patlax Business Solutions. I thank all the organizations who are doing such great job of enlightening the young minds who are the pillars of our beloved country. So I also take this opportunity besides to acknowledge the efforts of Director Research of our university, Dr. Ravi Kant, who played a pivotal role in organizing this webinar. So what exactly is the role of IPR in our day-to-day life? Well, I guess protecting IP or intellectual property literally keeps our daily lives functioning. According to World Intellectual Property Organization, which is WIPO, W-I-P-O, IP refers to creations of the mind, inventions, literary and artistic works, or maybe symbols, names, and images which are used in commerce. So technically, intellectual property rights or IPR have been defined as ideas or inventions and creative expressions based on which there is a public willingness to bestow the status of property. So IPR certainly provide exclusive rights to the inventors or creators of that property in order to enable them to reap commercial benefits from their creative efforts or reputation. So these are basically patents, copyrights, trademarks. Like patent is a recognition for an invention which is obviously globally, which has a novelty in it. It is non-obviousness should be there, and industrial applications should be there. So IPR is a prerequisite for better identification, planning, commercialization, and rendering, thereby protection of invention or creativity. So every industry should evolve its own IPR policies or management style strategies, so that depending on its area of specialty, like pharmaceutical industry may like currently has an evolving IPR strategy, I know better of, for requiring a better focus and approach in the coming era. Likewise, IPR is very important in all the entrepreneurships. Safeguarding intellectual property is critical for every business I know of, and it cannot be overlooked. So intellectual property helps in developing and maintaining any company's long-term revenue streams, and it increases the shareholders' value also. So in the current webinar, we have crucial talks on important topics like importance of IPR and the current IPR regime in India, wherein you will be getting a glimpse of current rules and regulations of IPR in India. Then Mr. Vikas Sharma will be discussing the registration procedures related to IPR, and he will also take a question answer round related to it. Then Ms. Lohita Sujit will be discussing about the copyright and trademark infringement, and Mr. Vijay Kumar will talk on patents and design. So I look forward for more such activities which will enhance our students' knowledge in this field. I hope more and more students from our university who are participating in this webinar and who are from various fields like agriculture, biotechnology, pharma, law, management will be benefited. And I wish great success to all the contributors and the knowledge gainers. Have a great day ahead. Thank you so much. Yeah, Mr. Rahul.
Thank you so much. Thank you so much.
Yeah.
Thank you so much, Dr. Prati Bhargava, for the keynote address. In fact, we are going slightly faster than what we had planned. So
Okay.
anyways, I've just requested for the vote of thanks to Mr. Dheeraj Jogi. He must be logging in anytime.
Okay.
Meanwhile, let me thank you for the keynote address and again about today's schedule. I would just take a minute off and ask him to log in because it's earlier than the schedule.
Okay, okay. Meanwhile, I'm glad to tell you that we, in our university, we have biotechnology, agriculture, law, management, pharma. In all the streams, we run 1 or 2 subjects or courses related to IPR. Especially in agriculture, we have more emphasis on farmers' rights, then the HYV varieties, then copyrights, obviously, then logos, and the pharma, everyone knows, deals with all the like logos, copyrights, and then all the quality assurance checks. And we have one center also where we work on herbal plant products, and we are working on it very elaboratively. And I hope new products will be coming out soon in the market, and there will be needing these IPR related activities for our students also and for our faculties also. So it's great that we have joined hands together, and I look forward for more such activities in the near future, which will be benefiting our faculties also. So I'll urge my faculties also to enroll themselves in the IPR related workshops or any courses which are run by you.
That's so nice to hear about your institute's interest also in the IPR sector. In fact, ICC has been doing a lot about in the IPR sectors, not only with the IPO office, but individually also. ICC has been doing this national IPR summits year on year. So I just had a word with Mr. Puri, so he might be joining anytime now.
Sure, sure.
Maybe Rahul, meanwhile, we can request students and faculties to post any questions that they may have, and
Sure,
maybe
sure.
speakers can accordingly optimize their presentations.
Sure. Students may kindly post the questions, whatever they have, and till the time we are awaiting Mr. Puri, we can take these questions.
Yeah. And I think students, you can come on videos as well. There is no problem. I think Mr. Puri is there.
Mr. Puri, are you there?
Yes, I'm here.
Good morning and welcome. I would request Mr. Dheeraj Puri, who is the co-chairman of the ICC Northern Regional Council, to kindly deliver the vote of thanks. Mr. Puri.
The representatives, the Intellectual Property Office, Representatives University, Mr. Arnab Dugal, the Project Associate, IPTCE Academy, ladies and gentlemen. Gives me great pleasure to deliver the closing remarks and the formal vote of thanks at the end of this very engaging session. The session could trigger meaningful discussions and deliberations by the panelists on different opportunities. It is recognized that the 21st century belongs to the era of the knowledge economy and the role of the intellect. Today, possession of land, labor, and capital are just not enough for a country to succeed. Creativity and innovation are the new drivers of the world economy. Within knowledge-based, innovation-driven economies, the intellectual property system is a dynamic tool for a wealth creation, providing an incentive for enterprises and individuals to create and innovate. A fertile setting for the development of the trade in intellectual assets and a stable environment for domestic and foreign investment. The IP plays an important role in an increasingly broad range of areas, ranging from the internet to healthcare, to nearly all aspects of science and technology and literature and the arts. In recent years, especially during the last decade, the world has witnessed an increasing number of cross-border transactions. Companies are carrying on business in several countries and selling their goods and services, entities in multiple locations across the world. Since IP rights is a country-specific, it is imperative in a global economy to ascertain and analyze the nature of the protection afforded to IPRs in each jurisdiction. India has robust IP laws and a strong IP jurisprudence. The legal framework does reflect the underlying policy orientation and national priorities, which have evolved over time, taking into account development needs and international commitments. Today, there is a greater awareness among the legal community and courts in the wake of the country's accession to agreement on trade-related aspects of intellectual property rights. That IPR is a significant driver of economic development. Indian courts have shown dynamism and zeal for effective protection of IPR. In the end, I once again thank speakers, participants, participation. Thank you very much.
Thank you, Mr. Puri, for the nice vote of thanks, and thank you so much for taking out time from your busy schedule for addressing the students and us.
No, not
Thank
at
you so
all.
much. And with this, I would request Dr. Sheetal Chopra, who is the Director IPR Policy, Ericsson India Private Limited, to please take over and take the technical session 1, which would be introduction to IPR, its role, importance, and the current IPR regime in India. Dr. Sheetal Chopra, if you could please come.
Sure. Yeah. Can you hear me, see me well?
Yes.
All right. Thank you so much, Rahul. And I think I must first of all thank Mr. Dheeraj Puri for quickly coming forward. I know the time was, we were quite a little.
I know, I'm
ahead
sorry, yes.
No, this is perfect. And your vote of thanks was also amazing. And it
Thank you
was
so
very
much.
apt. Yeah. And we look forward to continue to meeting you. And also thanks ICC and IPTSC Academy for inviting me. Mr. Vikas Sharma from Patent Office, thanks so much for joining in, and it's always encouraging to hear great efforts being taken by Indian Patent Office in nurturing that good ecosystem in this country so that people can flourish, they can create more, they can protect more. Saisha from IPTSC Academy already gave you some bit of information that how IP is very important not only for one particular sector. It's overarching. Whether it's a student, a teacher, professor, working professional, startup, IP is something that is your inevitable part of your everyday life. And in most of the lectures that I usually take, I always make a mention that those who are IP literate are always able to secure or get 45% more in terms of salaries and revenues as against those who are not IP literate. So IP is something that is going to give you not only monetarily, it will give you a lot of strength, but also it will help you in coming up as Atmanirbhar, as our current government always keeps quoting. You'll know nuances of IP. You'll be able to safeguard yourself from any potential litigation. And we've heard very recently the case of Google and Uber. I mean, these are the bigger names, and if they could be in the IP litigation, I mean, then it becomes very important for all of us to be aware of those basic nuances of IP. I have one small presentation to give because it's about the introduction to IP. Let me just start to show presentation. Entire screen. To see if you can see this presentation, or do you see some other screen?
Yeah, it's visible.
We can, yes, we can see it.
All right. I'll put it from the beginning then. So I have put in the logo of IPTSC Academy because they shared this presentation with me. It was compiled by them, which is one of its IP Olympiad that is conducted in collaboration with ICC. So this is a very important initiative, and I thought it would be good that I take the slides that they shared with me. So this is a very small disclaimer, and it is just to convey that anything that we speak today shouldn't be construed as any legal advice, and it shouldn't also be connected with the organization that we are affiliated to. This is an academic program, and therefore whatever is said here is only for academic brainstorming. And I would really request students and faculty members, whoever is joining the meeting, please come on video if you can, because it then helps us to not feel that we are talking to ourselves. Otherwise, मेरे सामने सिर्फ एक ये slide है and I can only see myself from the back, my shadow, and the presentation. So if you guys can put some question at any time, मतलब कई लोगों को ना एक ice breaker चाहिए होता है. They feel that maybe if we ask this question, it may be very lame question, but believe me, there are no stupid questions. There are never any lame question. Every question is as important as any other person who may ask it. So feel free. This is the opportunity for you. बात करें आप, because we are all gathered here just for you guys. So we will be discussing some of the, there are different sections under which we will take you through, some of the basic nuances of IP, some introduction to IP. Then we'll try to break some common myths that people have regarding IP. Some important case studies which are generally we may have heard, and or maybe the products that we generally use in our day-to-day life. We'll also talk something about capitalizing IP if time permits, because I think it's 45-minute session. Being given to me, out of which I thought we'll speak for 30 minutes, और उसके बाद 10-15 minute के लिए we'll have Q&A. So if you guys, I know all your names are appearing, please better be prepared for any questions that may come to you from my side. So it's a combination of slides which has lots of things. I think this is the slide which was given to me by, I think he was trying to convey that how, and not only for university but for yourself as well, because a lot will grant you, but And if you at this young age are able to understand all these important key things about IP, I think you will have better chance to get adopted or maybe absorbed in various organizations. The moment they see that in your CV you have undertaken any sort of IP Olympiad or you've taken any sort of IP knowledge in the form of short-term courses, any group discussions or competitive debates that you've been part of, whether you belong to a university that had a particular ranking and accreditations or not. So this is a moment for you to go to. I think कल जब मैं कहीं जा रही थी, I saw one banner of Delhi government, Mr. Kejriwal, wherein it was written Innovation Blasters, wherein Delhi government and I'm sure in various other states, similar initiatives are being taken. You'll find that students and faculties who come up with something creative and they make a presentation under that particular project, they are given a lot of cash rewards as well. There are similar other activities. There is Manak, there is Inspired by Ministry of Science and Technology. There is also CPET project under Ministry of ICT. So ऐसे बहुत सारे different ministries are there. CPAM is there. Indian Patent Office itself does a lot of recognition and rewards on World IP Day. So I think you can very well become part of all of this, because this presentation was not only about introducing you to IP, but also giving you a background of why IP has become so important now. There are lots of startups, आजकल जितना भी startups हैं बच्चों, they are coming up with, they are being generated from academic institutions. In fact, telecom में तो professors are opening up their own startups after they innovate something good, which is good for global standardization, which can help devices connect together. So similarly in pharma, similarly in agriculture, there is whole sort of innovation that is coming up, and you can be part of that innovation game. We'll now seep in through introduction to IP. I am not able to see the question if somebody may be posting, so Arnav, maybe you can do that logistic work from the back end. Just see if there are any question, you can flag those in between. क्योंकि monologue से ज़्यादा अच्छा कि dialogue हो. We should not wait for the presentation to end, but we should start discussing already. So introduction to IP, if you look at, there are some very important facets of IP. There are different forms of IP under which different ingredients can be protected. So अगर आप एक toffee आप देखिए, and it has a wrapper, and the moment you start opening up the toffee, you'll find that that candy has a lot of intellectual property within it. For example, the wrapper of that candy, where every instruction is written, or its ingredient is written, the way it is written, the color that it has, the particular code or the dress that the candy is wearing, all that is a part of copyright and trademark protection. As far as name is concerned, it goes to trademark. As far as written part is concerned, it goes into copyright. And the ingredients of that candy, that they may become part of the patent protection. So it was just a very simple analogy to let you know that one particular product can have several forms of IP. ऐसा नहीं है कि आपने कुछ एक चीज बनाई और वो सिर्फ एक ही form of IP में जा पाएगी. Anything that you prepare, anything that you make, you need to have a very, very broad view that different parts of that innovation can be captured into different variety of IP. जैसे I'm sure, like Saisha was saying, that IP Olympiad is even open for designers, for researchers and scientists. I'm sure some of you must be in from that particular domain. Dr. Prachi already spoke about a lot of people from pharma side and agricultural side. So you need to see that IP is not always about patents, never. It's about different forms of IP. It is also design. जैसे आप जो कोका-कोला की bottle पकड़ते हैं अपने हाथ में, or anything, like I have this Patanjali ka cream in my hand. So the way it looks like, its shape, it goes into design, and when you open it, the ingredient that you see inside, that goes into patent because it has specific way of treating maybe some sort of skin disease, or maybe making you more fair, or helping you in some other skin related issues. So इस तरीके से different forms of IP are there. Patents is the form of IP which is considered to be most strongest. It's a negative right whereby you can stop others from using your invention for good 20 years after patent is granted. It's not necessary that you will be able to manufacture, because for you to patent, come up with a manufactured product which is ready to go into the market, there is a whole process in between. There is a whole supply chain in between. You need a licensee, you need a licensor, you need somebody who can manufacture, you need a marketing manager who can market, you need retailers, you need shopkeepers. So there is a whole supply chain, right? So while you may be struggling, or while you may be collecting your own supply chain for your patented invention so that it comes from lab to market, however, while you're doing all of that, you can actually stop others from misusing or misappropriating it if they are doing it without your permission. Trademark, like the famous KFC chicken, Kentucky Fried Chicken, or any other, Burger King, those very the kind of trademarks that rings a bell, McDonald's. These are all trademark. These are the names under which trading is done. क्योंकि जब भी आप कुछ बनाते हैं, and when you want to sell it, certainly you need a name under which you'll be able to sell. Similarly, copyright is for 60 years. It is the form of IP which is, to the best of my understanding, is the longest form of protection. Why? Because 60 years start from the date after the author dies. So जब तक author जिंदा है, जब तक आपने, suppose you created some script in the form of maybe some research you've done, and you have put it in the journal into a publication form. Not only it will stay for 60 for until the time that author is alive, and 60 years thereafter. So that's why I feel this is the longest one as far as literature is concerned. As far as literary work is concerned, computer software can go into a copyright. Music, film, and any creative work can go into a copyright. Trademark also, like we spoke, is given for 10 years initially. Sorry, but it can be renewed after every first block is over. You can continue to renew it for next 5 years and 5 years. So it is like extended indefinitely. So in that manner, even trademark is the very, very longest form of protection. The only difference between trademark and copyright term of protection is that you need to renew trademark after 10 years are over. Copyright के लिए कोई renewal नहीं है. Copyright के लिए the day your work is created, it is up till the author's life, and then 60 years beyond. Then there is a trade secret. As the name suggests, it's a secret recipe which you may not want to show to reveal to the world, but develop your business on that secret work that is only with you. And we've got several examples, whether it's Coca-Cola ingredients, no one knows, and therefore Pepsi ka taste या Coca-Cola ka taste, no one has been able to replicate. Similarly, KFC का chicken, जितने लोगों ने भी बनाने की कोशिश किया है, they have not been able to replicate it because there is a specific sort of spice that is used, and that's where role of agriculture comes. And many of the students in this group today, if you are from agri side, you would know that a lot of ingredients have a medical value. A lot of ingredients from Ayurveda, they actually sensitize your palate and taste very well. So those things, if you want to keep it secret and you want to come up with a recipe, is where your trade secret comes into play. Like I said, one particular product can have several sort of IPRs. If you look at this whiskey bottle, Scotch bottle. The name, as you can see, is a form of geographical indication, because this sort of taste of whiskey or Scotch you will get only if it is grown, the ingredients are grown in that particular region. Similarly, the design of a bottle will go into design protection. The logo or the name under which this bottle is sold will go under trademark protection. And when you open the bottle and put it in your glass, the ingredients form part of the composition. Either it can go into a patent, or you may wish to just keep it as a secret. You don't want to tell to anybody as to what did you mix in what proportion. It's a strategic decision usually businesses make, and then the process of making that particular work. Because if you're going for a patent, what is most important is that the entire thing that you present in the patent application, where it gets also later granted, if examiner is happy with the prior art search, and there is no conflict, and if it's new, industrially applicable, then in that case you need to also show the process कि उसको कैसे बनाया, so that after 20 years people can reduce it to practice and come up with their own generic version. So it's not important just to tell the world about what you have prepared, but how you have prepared. So what and how are both very integral part of any patent, जो आपको ध्यान में रखना चाहिए. And patent is like a quid pro quo. It's like you give something to the society and you get something in return. What you get something in return is that exclusive period, 20 years ka. And what you give to the society in return is the complete details of your invention. आपको सब कुछ, you have to disclose everything to the public in that patent application. Of course, there are certain trade secrets could also be part of that whole ecosystem or whole IPR package, which you may not wish to still include in the patent application, but keep it with you for a tech transfer. For example, pharma ke jitne log hain, I think they'll be able to relate it better. So if you synthesize any compound in your laboratories, it is only at a particular temperature, maybe, or only in the presence of a particular catalyst. I mean, there are several catalysts, and there is a temperature range which may have been given in the patent draft. But it is only at that particular temperature that you will find that compound, that product gets made in a highest quality and in the purest form. That particular temperature, you may wish, while you have to give the range of a temperature into the patent application, but that particular secret formula, sometimes strategic business decisions are such that they have to keep it with them, safeguard. Otherwise, this is called part of know-how. Even that's your intellectual property. Now, whether you want to put it in patent, keep it as TS, is again a business strategic decision. So we can now progress to copyright, and this is yet another form, a very important part of intellectual property. I think we can stop here for a breath. And if there are any questions, Arnav, do you see still any questions posted?
Yes, ma'am, there is one question. The question says, why copyright issues are more in music as well as in cinema industry, and what efforts are being taken by IPR to minimize the same?
Arnav, you'll have to come back again on this question, and you have to also say the name of a person who is asking.
Yeah, am I audible, ma'am? So this is a question from Mohit. He's asking why copyright issues are more in music as well as in the cinematic industry, and what efforts are being taken by the IPR to minimize the same.
Okay, if I understand the question correctly, this is about the creative sector, which is where we've got music industry and we've got cinematograph industry where there are films being produced, and there is a recording industry where songs are being copyrighted. And the question is that why is it that we see a lot of litigations in music as against the cinematograph, which is audio-visual form, right? So, Mohit, it's a very good question, and I'm very happy to see that you've got such a knowledge, and you are an observant of this creative sector. We will have one session, I think after me, or one by Lohita. She's from Creative First and also represent Motion Picture Association. She will be able to also help you with more detailed answer, but I can certainly say that there are litigations, there are a lot of issues in both sectors. Okay. And like you rightly observed, there are more issues in music form, because that's the easiest thing that anybody can actually copy. It's a song. It could be either remixed. Some music here and there can be changed. Some lyrics could be changed. However, for a cinematograph film, it's a very complex product. It's a film which has lots of things in it. It has photography, it has different frames, so it has a particular storyline. So it's not very easy for people to copy that particular thing as it's, as against, people will feel that okay, music is someone who is which is most heard even while on the go. But I would definitely say that there are issues in both the sides. People are struggling. People are still saying that this film looks exactly the same. Do you remember Three Idiots movie and Chetan Bhagat, how he became famous? Because his novel was adapted in the form of a movie called Three Idiots, and thereafter he took everybody on the task, and they said that I am not being attributed in the film properly. People don't get to know that it's Chetan Bhagat's novel, which was taken by the film producer and prepared the film. But there are a lot of initiatives, as far as I understand, by the creative sector to put a stop on these things. If not stop, but at least curb. There are, for example, and I'll count you one by one. For example, number one, there are John Doe orders by Indian judiciary, wherein John Doe orders are to stop the website owners from playing any infringing content, whether it's movie or whether it's music, any infringing content. So even before movie is released, John Doe orders are taken by the film producer, so that if as soon as movie is released and there is some website seen hosting that movie, then you just send this notice of John Doe order to that website and put it to a closure and have an enforcement action. That's one thing which is happening in this creative field. Other is watermarking and D2H, which is direct to home, meaning there is no intermediary. Everything is coming from satellite to your home. Even in the cinema halls, there is watermarking given. So अगर आज आप जाके record करेंगे movie को, and that recorded version, if you try to put it on the website, it will give you a watermark of the name of the cinema hall where it may have been recorded, even the date and time, meaning उस particular दिन में कौन से part of that streaming of the movie was it copied. Then there is another initiative taken by in order to curb piracy, right? Like I said, John Doe or Ashok Kumar orders that you say, but lot of technological protection measures, TPM, as you say, where watermarking happens on the content so that anybody copies it, it is lifted. Intermediary guidelines are there today. Intermediaries meaning just say, websites, social media websites are there which allow people to host the content and download the content. Even now they are held responsible, whether it's YouTube. आपने देखा होगा YouTube पे अगर if somebody puts a video and it has a small clip, वो 3 मिनट मतलब 2 मिनट की भी अगर clip होगी उससे भी बहुत छोटी few seconds की, there is a copyright strike which is sent to the uploader of that particular content. So इस तरह से there are several initiatives taken, and I'm sure Lohita will be happy to speak much more in detail with you. I'll have this conveyed. Mohit, when she speaks, do ask this question once again. And if you want to know more, that is where you can ask from her as well. I hope it helps, Mohit. All right. Arnav, any other question that you see right now?
No, ma'am, there is only one question as of now.
All right. So then we progress. And how much time do I have, Arnav? By my clock, it shows 11:40.
Yes, ma'am, you have some more time. Just give me a minute. I'll check.
Just check the program copy because I should leave at a proper time so that other speakers are able to speak as well.
Ma'am, you have time till 12:15.
Okay, so there is a good amount of time. Okay, so copyright industry, like Mohit already broke the ice, and his question was a very good segue for me to get into this particular section on copyright industries. And like Mohit very rightly suggested, it's more seen in the entertainment industry, music industry, publishing, design, fashion, jewelry, gems, and information technology. Information technology, more specifically the computer software programs. So coding likhte hain, because computer software per se cannot be protected under a patent, even if however much or longer the software code is, the code, because it is only understandable by a machine and not by a human being, so it is a part of a copyright. But when that code, that software is able to solve some issue, for example, it is able to help your searching become more customized and easy, or there is some software which helps in saving your battery life of your phone, or there is some software which can recognize your face and can open up the entire system for you. So any software that is able to solve any technical issue is then patentable under our section 3K of the Indian Patent Office. Not patentable, but it just says that under section 3K per se, the computer software is not patentable. But when you look at various cases where various instances where patent is given a protection, it is for the solution that software is producing, as I've just gave you some of the analogies. Publishing sector में the entire set of books, I'm sure बहुत सारे लोग आप में से must be having a knack of writing books or music, film, scripts. That is where copyright comes into play, including fashion industry, or the entire design of jewelry pieces. And today we see nowadays a lot of jewelry designs getting copied. आप एक shop में जाएंगे, you'll see similar design there. But if you go to another shop, they'll say these unique designs you will find, madam, sir, only in my shop. Why? Because they've been able to safeguard it from not getting pirated. Kyunki they keep a complete track of who is entering into their shop. Are they the right customers? And before presenting their design jewelry to them, they'll make sure that they convey to them that it's copyright protected. Meaning people are becoming a lot literate about their famous designs, and they don't let it out. So उनका एक diary रहता है, which they keep it secret only with them, and they don't let people be aware, or other designers. कई बार competition में people try to copy each other work, but there are some very complex design that people will come up with and get it under copyright protection. So what is copyrightable? Like you all may be already knowing, idea is not copyrightable. Matlab, it's only the expression, the way you express that idea. So if there is a storyline which says कि एक सास होगी, एक बहू होगी और एक पति होगा, and then that particular storyline में सास and बहू में will be either a very good relation or a bad relation. So इस तरह से you would see that there are several scripts, in fact सारे Indian serials are almost on this particular line, which shows that idea per se is not protectable under copyright. It's only how you express that particular thing in a particular format is what it's like. Originality, it's like the expression. So this is called as idea, concept, expression dichotomy. In fact, it's a trichotomy. These are the three things, where there is an idea, and then there is a concept behind that idea, and then how you express it. These are the three things which are seen. And it's originality versus novelty, meaning it has to be original in the way it has been expressed, but it may or may not be novel. Matlab, the script that I just told you may be known to everybody. There may be TV serials on it, but it won't stop others from coming up with the same script, meaning same background, Saas, Bahu, and that husband. They'll be able to prepare, make many more storylines on it, having that basic concept, and they'll be still able to come up. So novelty is not as much seen. What is seen is the originality, how original you were while you were expressing your feelings, your input for the public view. So there are moral rights. There are two types of rights that any copyright protection gives you. It is the right to paternity. Paternity का मतलब क्या होगा कि इसका parent कौन है? Meaning who is the one who created this work first. So for example, if you're a book publisher, if you're a book writer and you want to give it to a publisher for publishing a book and communicating it to the public, then even if you give away your copyright, let's say to that publisher कि ठीक है आप copyright रख लो and you give me the royalty, still the author will remain to be you, right? And you may then decide whether you want to give copyright to the publisher or not, but authorship will always remain. If you give away the copyright and the other person has the complete right over its marketing, changes in that script of that copyrighted work, even ऐसा भी हो सकता है that if you end up giving your copyright to the book publisher, he may ask you for a money that okay, now if you want to make any changes in the book that you only wrote, you'll have to pay me X amount. And tomorrow if that book publisher closes down his business and you want to publish the same book with some other publisher, and God forbid if you've given away your copyright to that publisher, you'll have to pay to that publisher to get that copyright back. So be very careful. I'm sure SRM University, your university is coming up with a lot of creative work. I'm sure there'll be a lot of book authors, existing and prospective. Don't ever give away your copyright to the publisher. When you sign up a royalty contract, always make sure copyright remains with you. Authorship certainly will remain with you. And also you secure the rights to make at least first 5 changes in your book. It shouldn't happen that you've given the script, it gets published, and later even for one change in the book you have to give away your money to the book publisher. So इस तरह के ना nuances हैं. मतलब एक होता है copyright के बारे में जान लेना, एक होता है उसके पीछे की history. For example, like I just gave you this case studies of what may happen when you start to get publish your book with any publisher. These are the things that they may come up. So those are the critical things that you must always try to learn from the experts who may come in your university for further lectures. Keep publishing, and if you are facing an issue, do ask that these are the things that even I faced, so that others can learn. Besides right to paternity, right to the parentship of the work, it is also called as right to integrity, which means even if your copyright has exhausted, or even if you've given away your copyright to somebody else, that someone else will never have any right to mutilate or distort your work. So आपने कहीं सुना होगा एक गाना था which was मैं झंडू बाम हुई डार्लिंग तेरे लिए, and झंडू बाम, the I think it belonged to Dabur company, and they highlighted, they rigged up the issue and they said that this is not the way you should use my brand name. Similarly, the one who writes a particular music, and if you try to spoil the music, या उसमें आप कुछ ऐसा डाल देते हो which is not very pleasing to ears, it's almost like mutilating or distorting the work. And even if there is a particular work of particular length, even if the copyright has been assigned to somebody else, then that somebody else should not be reducing it to an extent that it loses its meaning, its sheen, unless if someone has to do it for technical reasons, he or she may be allowed, but otherwise mutilation is not allowed. So these are the two rights that are inherent when it comes to copyright protection of your work. One has to be careful that copyright protection is lost the moment more than 50 copies are made. I'm sure the girls out here, when you go for designer clothes, कोई लहंगा आप खरीदने जा रहे हो, and that shopkeeper will tell you, madam, I have only one single piece, it's a designer piece. Why people keep one particular piece or two particular piece or less than 50 articles? Because they know कि अगर 50 से ऊपर बना लिया, then they lose the copyright protection. And if you've not taken a design protection, you lose another protection as well. So there is a very strong linkage and a crossover between copyright protection and the design protection, which one must be aware of. Registration for copyright is not important. It's not mandatory. India is a part of a Bern Convention, which means आपने जब भी वो काम create किया है ना, आपने suppose कोई कुछ किताब लिखी है, आपने कोई script लिखी है, आपने कुछ लिखित में काम किया, आपने कोई software, computer software बनाया है, which can be used in your agriculture university to make the inventions more easy. Then copyright protection is not very mandatory. मतलब आपको copyright office जाके your online filing is not mandatory, but it is advisable to get a copyright protection, because God forbid if there is a court action, if there is a litigation tomorrow, and if you want to sue someone or someone sues an X person, then you must always ask, where is the copyright registration? How do I know that that X person or Y person is the real copyright owner of that work or not? So all that becomes easy to prove the ownership when you have got the registration done. But as I said, India being part of Bern Convention, registration is not mandatory. So this brings us to the next part of the session. Arnav, are there any questions that you see on the window?
No, ma'am, not yet.
Okay. I hope I'm going very clear. It's not boring because usually in different sessions, there are a lot of questions. So maybe there is still no icebreaker. I know Mohit, you did a great job in asking the first question, but I encourage others also. आपके जो मन में आ रहा है, any type of question, you please ask. Your monologue is very, very boring otherwise. So let's then have a segue into another form of intellectual property, and you see everything that you see in the slide here. The rack of Almira that you can see, the design in the garden, or the scooty on which the lady is standing, very comfortable chairs as you can see. And there are several other designs that we see all around us. I mean, मुझे तो ऐसा लगता है जब हम market जाते हैं, तो first thing that brings our hand onto a particular product is वो दिख कैसा रहा है. And then of course utility is inevitable. मतलब आपको ये तो देखना ही है जो मैं खरीद रहा हूँ या खरीद रही हूँ, is it of any use to me or not? But if you've made a choice and if you want to purchase an item, besides its utility, you will definitely see how it looks like, because each time you want to use the product, you'll want to see it in a particular beautiful form of the work. So if you look at this slide, even for the cars, वो WagonR का तो if you see those who've seen old WagonR, the new WagonR, it completely looks different. So even in the car industry, people struggle very much to make their car look different from the other brand owner. And that was, I think, was the reason why WagonR was changed, where it looked like a particular form of a box, and it looked like a Mahindra car also to an extent. It changed the shape. And in the design sector, there are a lot of litigations which are filed for minor changes in the design as well. So many of the people are thriving their businesses basis the design that they put on their innovative product. And there are many examples, as you can see. Design registration, sometimes people get confused with the patent registration. For example, just to help you explain this, consider you're going for a travel and there is a trolley bag and it has wheels. It has a particular form of that handle that comes out when you want to push it and you want to travel with that bag everywhere. And it has a particular design. Now people will ask a question whether it will be apt for a design registration or whether it will go into a patent, because this also has a utility. What utility? That not only that it looks beautiful, that particular design is in such a form that there are lots of zips. If there is a zip for every other particular thing that you want to save or put in there for easy access, but it also has a wheel. It also has hydraulic pull that you can use the handle for your ease. तो अब लोगों को confusion हो जाता है कि अब whether I should protect it under patent or design. So I think and Dr. Vikash is there. I'm sure in his workshop when he gives it to you, he'll be able to give you clarity on what are the nuances which are seen for design registration and patent. But the key difference between the two is that in patent, you have to show the feature, the utility of that feature. So if that trolley or that razor, which that the three, whether the particular design of a razor actually helps you cut the beard in a certain way, then it is good for patent registration. But if it is just a mere design, but it doesn't have any functionality in the form of a unique thing that we talk for that trolley bag or that for razor, then it goes for a design protection. So that's how you have to distinguish where there is a utility, it is able to solve some problem, it is able to give you some solution, then it goes under a patent. But how it looks like, just the outer feature, that's just how it is appealing, how it is appearing, is what goes into a design registration. So you can see this particular graphical representation, which says that design, if it is functional or utilitarian, then it goes under a patent, like I just said. If it's purely an artistic work, they said just the jewelry design, like we just spoke about, the look and feel, then it goes under the copyrighted work also. But you get into a design registration when it has industrial application as well, when you are able to industrially use it. तभी मैंने आपको बोला कि there is a very strong connection between copyright protection and design protection. While you may have just put something onto a paper or a piece of paper, you have just expressed it in a particular form, but the moment it becomes industrially applicable, जैसे आपने design of a frog बनाया and you now start preparing frocks, actual frocks, it has industrial application, then it goes under a design act. So people also are confused sometimes कि मैं इसको copyright में protect करूं या इसको design registration दूं. And that is also a very strategic decision depending on what, number one, that work is. Second, what are you going to do with that work in future? Third, whether can it be reduced into industrially applicable work or not? Would you be able to produce several designs out of it, several 3D formats, 4D, 5D? That's how you will make a distinction. Whether under which registration you want to secure your intellectual property into. There are certain things that you need to be careful about. Keep it secret unless it is filed, because there is a prior art. If there is a prior art, meaning it is already known, then it may be an issue. It should be filed within 6 months. If at all it is used for any experimental work, that's a grace period given. And mention articles on which design is to be applied, meaning किस पे आप वो design डालेंगे, whether it's an apparel or it's a box, what sort of, or it's a car, meaning that design is for what sort of a product is what you have to clarify. Like I already mentioned, there is a key distinction between the two, and at your convenience, you can read it at a later stage. But one of the key differences also in the term of protection, एक 10 साल के लिए plus 5 years, maximum 15. While for copyright, we've already discussed until the time of an author plus 60 years. And then we know that 50 ka benchmark, that you don't have to go beyond 50 to come up for utilization of your work. Then we go to the next slide. Arnav, do we see any question on the window yet?
No, ma'am, no questions yet.
All right. So trade secret, we've already spoken. It's a secret formula. It could be a practice. It could be a process, design, or an instrument. And there are, in some jurisdictions, such secrets are referred to be as confidential information or classified information. In India, we don't yet have a specific copyright trademark act, trade secret act, sorry. It is under the Contract Act. If there is some litigation, then under the Contract Act, one can seek for relief. But there is no specific law on trade secret yet. But all what one has to do is to keep it secret, to put in certain scheme of things, to put in certain processes in place so that it doesn't get stolen. You just need to make sure on that front. And if it is stolen, then it becomes very difficult. Trade secret, once stolen, is up in the public domain, then it doesn't remain to be a secret anymore. And we've got several examples to talk about it. For example, Coca-Cola, we've already seen. And they refused to reveal its trade secret under at least 2 judges' order. Because they said if during the litigation we reveal what it is comprising of, then there is no trade secret anymore. You'll find copy-paste of generic forms of Coca-Cola everywhere, every nook and corner. And people who know the formula, they never travel together, for the reason that if something happens, some misfortune happens, meaning they have some tragedy, so at least one person will be safe enough to keep secret that secret formula, so they never travel together. Similarly, for KFC, we know this brand so much now, and there is a menu script that runs into 200 pages, and it has chain of restaurants in 108 countries, and there are several people who are in receipt of that spice who are then cooking it for us. No one knows which part of that ingredient comes from which country. So KFC sources different ingredients of that masala that they put on the chicken from different countries, and it is saved in KFC vault. No one knows how that recipe, what that recipe is. McDonald's special sauce, as you know, no one is able to copy paste it or come up with a similar taste. So even there, the actual containers are not known, and the sauce is delivered to McDonald's restaurants in pre-sealed container. ऐसा नहीं कि ingredients आते हैं and somebody in one particular country mixes it and then delivers it to other countries, exports it. No, it comes from a particular in a particular country in a container from somewhere, and then it is opened up by people who are in receipt of it. So no one knows how that special. It is a mystery. And similarly, there are several other what we just said, such secret recipes which are not known to people, like Pillsbury Chucky Fresh Atta we just spoke about. Now, there are merits and demerits both of trade secret, because like I said in one of the slides, if you remember, people have to take a strategic decision whether they want to keep that entire thing as secret, or they want to reveal it to the people in the form of a patent as a quid pro quo. And there are merits and demerits both, and you have to see what suits you the best. For example, merits are that people don't get to know about it until the time it is safe in your own walls. While in patents, everything will be known. It is in the patent application before even it's granted. After it's granted, during the term, you might have to supply a lot of more information. The demerits of trade secret are that it is very difficult to license. क्योंकि आप license कैसे करोगे ना? You're giving your recipe to someone, and you're saying, okay, you can make it now. You have to reveal, right? And if that cannot happen because it was never you didn't want to patent, but you wanted to keep it secret, then you have to come up with a non-disclosure agreement that, okay, I'm sharing it with you, but only one particular person in a whole company will know it. And after this license is over, that every piece, every paper has to be destroyed. And if someone by any chance gets to know that person from the licensee who knew about that trade secret will be under a lot of penalty. So you have to draft a lot of things in your contract in order to make sure that your trade secret can be easily licensed. So that's the demerit. But there are several other merits, like there is a longer form of protection, like the longest form of protection, if I may say, until the time it is kept secret. There is no registration fee that you have to pay, because आपने कभी register करना ही नहीं है उसको. You have to keep it secret with you. While demerit says that it is susceptible to thefts and exploitation. If someone gets to know, someone can reverse engineer, and if there is no specific law in it, enforcement becomes very difficult. So these are the things that you have to see. If someone comes up with something very interesting and you want to see whether you want to patent it or put it under a trade secret. Okay, now this brings us to the next section of today's session, which is on patents. And there are a lot of key facts to look into it. For example, what is the term of a patent? What does it give you? What all does it allow you? For example, there are unauthorized acts. If someone is making your invention, using it, importing it from some other country, may not be making it in the country where it is protected, but importing it from the country where it is not protected, right? हो सकता है इंडिया में लेके आया किसी और country से. Even that importation will be an unauthorized act. Selling it certainly is an unauthorized act, so you can stop others from doing it. The only tricky part is that the enforcement becomes a lot difficult. आप कैसे पता करोगे कहाँ पे कौन आपका चोरी करके invention जो है is in the market. So an inventor has to be like a जिसे कहते हैं ना holistic personality. Not only he or she has to be an inventor, he must know the nuances of IP की filing कैसे करना है. That person should know how to interact with the legal counsels, the law firms with whom that person may be working. Should also know the business side कि मैं इस invention को market में कैसे लेके आऊँ. Should also know how to make a pitch to the investor for various rounds of funding. So there are a lot of things that this field of innovation and creativity will guide you. It will like make you a holistic person. You should not leave certain parts of your invention to other people. ठीक है, मैंने invent कर दिया and somebody else will draft completely and I won't take care of it. And okay, somebody else has drafted, protected, and I'll leave it to some other marketing agency to do that work. I think while you may outsource this work to several other people because they are the doctors, they are the the right surgeons to do what should have been done with your invention. But you as an inventor must be aware of all these basics so that no one fools you around. And that's where marketing skill, managerial skills, administrative skills, innovation skills, filing skill, being a good drafter yourself. It's like a holistic personality one should try to become. And I'm not saying that you don't outsource your work to people who are rightfully should be doing that work for you. Like there are social media people who will do social media marketing for you and they are better at it than an inventor, because an inventor has to focus his or her energy on coming up with the best work. But all I'm saying is that one should be aware of all these other peripheries of innovation ecosystem as well. Then what is patentability? I mean, what gets patented is the three things I've seen, which are very basic. Matlab, your invention has to be novel, right? It cannot be somebody may have invented and patented it in US and never did it in India. Doesn't mean कि आप India में उसको protect कर सकते हो. Anywhere in the world, if someone has done that invention already, it's a part of the art. It cannot be protected. And there is nothing called as global patent. There is nothing called as worldwide patent. कि मैंने आज इंडिया में फाइल कर दिया doesn't mean that you can stop somebody else use your invention in some other country. ऐसा नहीं है. It's a territorial right, meaning every territory, wherever you want your patent to be protected, you have to go and ask for protection. You have to resolve the issues that may be asked by the examiner. You have to go through the entire process of examination of your patent application to get it granted. So जैसे आपका invention which is meant for US, let's say, more for that particular area, तो आपको US में protection चाहिए. May not be then in Japan because maybe that particular product is not helping Japanese people. But if you want that protection in Japan, US, and several other countries, then PCT is the route that you can take, which is one single stop shop. And I think in the subsequent slide, I may have one slide on PCT. And then the second thing aspect which helps you get your patent granted is non-obviousness, which is the inventive step. Meaning, what is the inventive threshold? ऐसा तो नहीं कि बहुत obvious था that you made something similar to what may have been already done by somebody else. And finally, the industrial application, meaning can you reduce it to practice? Can it be industrially made? Can it be scaled up? So all those things are seen. This is a very important section of Section 32 of the Patent Act is also very important. Plus, you must know that before filing a patent application doesn't really matter whether you have completed your invention or not. Therefore, there is a provision of provisional patent application, meaning you at the outset, after you've started to work, you have a concept ready, you've reduced it to practice to an extent, you've done some R&D, and then you can file a provisional patent application without claims, without claiming what your invention is at that stage, because you don't know at that time. But you certainly want to file for it so that you become the first one to be known by the public that you are the first one who started working. And then within a year time before it lapses, you can file the complete specification, which is where you can then claim your invention, have the structure of claims. PCT, as I just spoke to you, it gives you enough time of 31 months, which is close to 2.5 saal, to make a final decision whether you want to go in other countries or not. There are some common myths around patents. For example, people think that patents are only for pharma, medicines and composition. It is not. It has for ICT, for manufacturing, for opticals, for narcotics. I mean, there are so many variety of inventions in different fields that can get patent protection. And well, this is a very old slide, but which shows that, you know, I mean, to me, it seems like a very frivolous invention. As we speak in 2020th, I mean, we are in this century, 2021, it's going to be over, getting into 2022. I mean, this is US patent number, agar aap dekhoge 4233, it's very, very old invention where even the clip which could sort the hairs of a dog were protected. मतलब उस time पे ऐसा था कि everything and anything under the sun invented by men could be protected in US, but abhi wo story has changed. Even in US, USPTO is looking into, and of course, thanks to Indian laws and so robust laws, where frivolous inventions are not allowed to be protected. You need to really show utility and inventive threshold to protect it. And there are no global patents, like I said, no worldwide patent. And I think we can go on and on. Softwares are not patentable. I've already taken this up for you. That per se the code has to go in copyright, not the patent. Patents are very expensive to obtain is another myth. Like Dr. Vikas in the morning in his keynote session, he said that now Patent Office has reduced the filing fee and total overall fee for academic institution by more than 80%. So वो बहुत अच्छा initiative है, which has reduced down to a lot of fee liability or overload. So it's not as expensive anymore. Everything lies in managing the unwanted cost, how you really take care of your invention. Well, I think I should stop here because it's 12:12 right now. And I think we must give people enough time to now maybe talk for next 5 minutes. Dr. Vikas, if you have any quick inputs, you can please help us. If it was overall okay, and if it is a right segue into your presentation.
No, it is very useful, I think, and right platform to start me regarding patents, and I'll be giving the brief.
Good. Right. So I'm happy, Dr. Sharma, that you were there while this was being presented, and I'll be more than happy to hear what you now present. And then it will be easy for other speakers to also then not replicate what previous speakers may have. So वो अच्छा हो जाएगा. And I think I'll stop here. It's 2 minutes still left. Arnav and Rahul, if you are around. Yeah, Rahul, please, over to you now.
Yeah, welcome back, Mr. Vikas Sharma. And it was nice hearing to Dr. Sheetal Chopra, although I was on mute and video was off, but I could hear. So it was nice introduction to IPR. Some questions also put up. I believe you will be taking up questions later.
Yes, thanks.
So that's great. And would request Mr. Vikas Sharma now, who is the Deputy Controller of Patents and Designs, Office of the Controller General of Patents, Designs and Trademarks, which falls under the DPIIT Ministry of Commerce, would request you to start your session, sir. And this would be on protecting IP rights. You would be talking about the registration procedures. Mr. Sharma, please.
Yeah, wait a minute. I'll just start.
Okay.
Thanks. Those things कैसे हमें So Rahulji, are you able to see the screen which I am sharing?
Yes.
Okay, fine. So basically, I'll be talking about mainly about the procedures regarding this patent filing in India. And so these are the statutes which governed IPR in India: the Patent Act 1970, then the Trademark Act 1999, Design Act, Geographical Indication Act, Copyright Act, Plant Variety Act, Semiconductor Act, Biodiversity Act. And we have seen number of times these they have been amended. And this is just to keep in the tune with the what IP demands from us, from the government side. And now we work under this Controller General of Patent Design Office. We have got RGNFM, where trainings and all are being conducted regularly. Then we have got patent offices at 4 locations at all major metros: Calcutta, Delhi, Chennai, Mumbai. Then design offices in Calcutta, trademark registries in Mumbai, Delhi, Calcutta, Chennai, and other than that, it's also in Ahmedabad also. And then GI's registrations are being done at Chennai. Now, these IPR laws like Copyright Act, again, now it has come into DIPP only. DIPP is the our ministry, which now is also dealing this Semiconductor Layout Act. Then Department of Agriculture and Cooperation, they are dealing with the Protection of Plants Variety and Farmer Right Act. And then Competition Act 2002, this is under Ministry of Company Affairs. Now, actually, what is intellectual property? If I talk, this is which is a creation of mind, which can be literary or artistic, design or symbol, names and images used in commerce. Like Sheetal, Dr. Sheetal has already covered. Now, what is the significance of IPR? This you all know. What is the significance of IPR? But basically, it avoids the duplication of research. It is what happened one time, actually, if I tell you the honestly, there's one tire company. They were working on one particular tire set. After 50 years, again, they developed the same tire set. So it is only because they didn't check up their own records. So I mean, it avoids duplication of research if you search your own databases and all. So other than searching others' database, you also need to search your database also. And there are a number of other benefits which have been listed here, like you get encouragement for the improvement of technology, because with new technologies you get encouragement, you are able to stand in the market. Like we have seen the Nokia case, that Nokia mobile, they were using Android technology. They were not using an Android basis, so they are out of the market. But they have again started using, so they are in. And with this, you are able to achieve number of things. You are able to create your identity through a brand. So like in a single product, like Dr. Sheetal has already covered, in a single product itself, you are able to have patents, trademark, trade secret and all. Now, what is a patent? Patent is basically a monopoly right. This is granted by a government. This is a sovereign right on behalf of you all. Actually, we sitting in this office, say in IPR office, we grant this. So basically, government has devised out this mechanism that the inventors will come to patent office, they will submit their invention, then we will give them a right. That right is for 20 years. This is a negative right, and this is a territorial right. We mean to say that this will be valid for India only. Now, what can be patented? All processes and products which are, it has got 3 embodiments. They should be new, they should have inventive step, and they should have capable of industrial applicable. Now, by new, what we mean? By new, what we mean that it should not be published in India or elsewhere. It should not be, because I've seen few cases that where people themselves have come to the patent office before filing to the patent office, publishing their invention somewhere else. So we were sorry to refuse their invention. So first disclosure should be to the patent office. Then in prior public knowledge, it should not be this, like you have already created some demonstrations in the public, that is not allowed. And it should not be claimed in any claim in the specification file in India prior and published later. We'll see this, what kind of this is this, because claim is something which is little bit technical. And now no anticipation by publication. Sometimes it happens that somebody actually without your consent publishes your invention. Then you have got certain remedies. So it will not be treated as public anticipation. It will not be working against your invention. And but you have to be reasonably and it should not be commercially worked. It should not be like this, that your invention is commercially worked, then you are coming to the patent office. And like no anticipation, if you have displayed your invention in public, public exhibition, and if it is read before the learned society, provided it is within 12 months, and it should be publicly worked, provided application is filed within 12 months. And if the use of the invention is a secret use or by the government to check its merit, for example, then also it will not be treated as anticipation. And if I tell you of one case like sewer, if somebody has dwelt something on the sewer, naturally it has to be shown in, or it has to be demonstrated in public. Then probably you will get some this relaxation, provided you come to the office within a reasonable time period. Then there is a second limb of this invention is inventive step, on the basis of which we judge sitting in the office that whether we should grant patent to your invention or not. That is inventive step. And this is a feature that involves technical advancement as compared to the existing knowledge. So here two things are coming into the picture: technical advancement, and then second is your existing knowledge, and then having economic significance, or both, that makes the invention not obvious to a person's skill in the art. And the third thing which is coming is not obviousness and a person's skill in the art. Because see, if it is food technology sort of thing, then the we will impute our knowledge to the level of food technology only. For example, if I am a mechanical engineer, and actually I am a mechanical engineer, and I deal with the inventions related to the agriculture implements, you may say. For example, I've seen one gentleman from Haryana. Actually, he visited to the patent office. He developed one. I was knowing this, that he has developed with governor. Governor means for speed controlling thing. But he said, "This is my engine ka chaukidar," right? So I mean, then we need to impute our knowledge to that level. So that is a person's skill in the art. And to be very honest with you, when he came to the office, he was, little shabby and all, but when he got this patent and he was capable of commercializing that, and he earned a decent amount from this. And then industrial application, that your invention should be capable of being made or used in industry. Now this is all section 2 says what we can grant patent to, but actually to certain extent we cannot grant patent to every invention. There we have got certain exclusions, like section 3A, frivolous machine, inventions contrary to the well-established natural laws. This is section 3A. For example, you come to us and show that this machine can give a output which is more than 100%, which is basically impossible. So that sort of inventions we cannot grant patent. Then section 3B, for example, the invention, the primary or intended use of commercial exploitation of which could be contrary to the public order or morality. For example, you come up with any virus, and so that if you put in the system of, say, Pakistan, and their whole system gets hanged, sorry, we cannot grant patent to you for that. And then the causes, like section 3B, it can cause serious prejudice to health, human, animal, plant life, or to the environment. Like method of adulteration of food or drug or medicine, sorry, we will not grant patent to you. Then section 3C, for example, mere discovery of a scientific principle, or formulation of abstract theory, or discovering of any living thing, or discovery of non-living substance occurring in nature. For example, Newton's law or semiconducting phenomena such as property of certain material to withstand mechanical shock, discovery of microorganism, discovery of natural gas or a mineral, will not grant patent to you. Like I already told you, this naturally occurring microorganisms, we will not grant patent, but GMOs, if you are genetically modifying them, we will grant patent to you. Then section 3D, this is little, in news also, because MNCs were involved. They went up to the Supreme Court. I mean, you can feel the gravity of the situation, what was happening around. So, but see what the section says: the mere discovery of a new form of a known substance, which does not result in the enhancement of the known efficacy of the substance, will not grant patent to you for that. For example, if you all know aspirin is used for what, and if somebody says that now we are going to use it for a heart ailments, for detecting heart ailments, sorry, we will not grant patent to you because that molecule is already known to us. And then mere new use of neem. But if your product employ a new reactant, then we can think of granting patent to you. And then for the purposes of this sect, salt, ester, ethers, polymorphs, metabolites, pure form, particle size, isomer, mixture of isomer complexes, combination, and other derivatives of known substances, they shall be considered to be the same substance unless they differ significantly in properties with respect to efficacy. Here, what is important is efficacy, and actually, Novartis AG, they went up to Supreme Court, and then Supreme Court decided what is efficacy, and they have interpreted the meaning of efficacy. If you see Patent Act, actually, if you see the Patent Act book, in efficacy is defined there. Now, Supreme Court has given this interpretation that to this efficacy, it means the ability to predict a desired or intended result. New form of a drug must demonstrate an improvement in its therapeutic effect. So the basically now our chemical persons, whenever you are coming with a new drug, they try to see if there is any therapeutic effect or curative property as compared to the older form in order to secure a patent. So with the basis of this, we then think of granting patents, and it has to be judged strictly and narrowly. Now, section 3 is there. It is about synergy, like substances obtained by the mere mixtures resulting only in the aggregation of the properties. For example, if you add A and B and you get the result only A plus B, then we don't grant patent to you. But if you mix A and B and you get result as C, then definitely patent is there. For example, soaps and detergents, lubricants, etc. And then section 3F, it is for mechanical implements like mere arrangement or rearrangement of the duplication of known devices which were already in existence. If you just come up with their combination again, for example, a bucket which is fitted with a torch, we refuse this application. Umbrella with a fan, like if I'm not wrong, that old Nokia phone 1100 where you used to have when we used to switch off the phone, even the alarm again used to ring up. That probably that application was not before us, but if it would have been, probably this is only two devices which were independently working, so they are not working independent to them. So we generally don't grant patent to them until unless we saw something which is synergistic, that is enhanced effect. Then again, this is like agriculture institute. So method of agriculture or horticulture, we don't grant patent to them. For method of agriculture or horticulture, we don't grant patent, but any agriculture equipment, if you come to us, we grant patents to them. And like cultivation of algae, this production of new form of a known plant, preparation of improved soils, we don't grant patent for those things. Then section 3I is there. Any process for the medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human being or a similar treatment of animals to render them free of disease or to increase their economic value or to that of their products, we don't grant patent to them. For example, removal of cancer, tumor, removal of dental plaques and caries, surgical processes relating to therapy, blood transfusion, a method of vaccination, if some doctor develops some good method, but we don't grant patent to them. But any apparatus relating to them, surgical, theoretical, diagnostic things, we grant patent to them. They are patentable. So in nutshell, I'll say agriculture methods, these surgical methods, they are not patentable. But if you come up with equipments, implement, we grant patent to them. Then plants and animals in whole or any part thereof, their seeds, variety, species, essentially biological processes for propagation or production of animals and plants, we don't grant patent. Then section 3K, again, this is related to mathematical method or business method or algorithm or computer program per se. We don't grant patent to them. But if you have got a combination of hardware and software, we will grant patent to you. Then literary, dramatic, musical or artistic work or any other aesthetic creation, including cinematographic work and television productions, we don't grant patent because they go under copyright protection. Protection is there under Copyright Act for them. Then mere scheme or rule of method of performing mental act or method of playing game, we don't grant patent. Like scheme for learning a language, method for solving a crossword puzzle, method for learning a language, method of teaching learning. And then presentation of information, any manner or method of expressing information, whether by spoken words, visual display, symbol, diagram, any information recorded on a carrier, this is not patentable under section 3M. Then topography of integrated circuits, again, not patentable, because for this you need to go under different protection, that is under semiconductor this layout. And then section 3B, which is related to traditional knowledge or aggregation or duplication of known property of traditionally known component or components, we don't grant patent for them. Because, for example, traditional knowledge already in public domain, wound healing property of haldi. No, so this is getting boring actually, what I'm speaking, but like we see the haldi case. Even haldi could not have been patented for this traditional knowledge use, but what happened in US, they granted patent for this. Then because in no document we were able to show that haldi is having this wound healing property. Then in one of the Iranian document, it was shown that it is having wound healing property, and with that thing we were able to revoke that patent in US. So I mean, this literatures and all they mean. Only thing is, it is written in legislation, then somebody in public or somebody from the government side need to come up and so that right things are being granted. Now you may say that we have given so much list that this is not granted, this is not granted. Even I'm in hurry, but see, actually, other than that, whatever is left out, that is patentable. So if it is not mentioned in section 3, 4th or section 5, then it is definitely patentable. In fact, section 5 is again being changed now. And now, if your invention, for example, you come up with an this defense-related invention, we don't grant patent for that. For that, secrecy directions are issued, they are being reviewed, and we don't publish them. If defense says don't grant patent, we don't grant. If they say you can go ahead, then we grant patent for that. Then non-patentable inventions, like for atomic energy thing, like these are the prescribed substances there. A list is prescribed, it is being updated regularly. We don't grant patent for them. And product patents, for example, for your thing, like these days have been product patents have been allowed from 1/1/2005. Now, use of biological material, it should be deposited in international depository prior to filing of application, and the reference of should be mentioned in the specification. Specification should contain all the details of the said material. Geographical origin of the said material should be disclosed. This is mandatory for biological material. Like just in the beginning remark, I told that this is maybe yesterday only it was soil day. So in our soil, we have got number of things which we need to have protection. Now, this is all about what are the process of filing, from filing to grant of the patent. First you file an application, it can be provisional or it can be complete, then it has to be published. It can be early, it can be made early published with a payment of fees. If you don't do that, we will do it automatically after 18 months. Then after publication, there is a request for examination, and this has to be done within 48 months from the priority date. And then examination of that is issued, examination report of that application is issued. Then within 6 or 9 months, you need to file your reply. And then, see, this is all public, public procedure only. So within, until we have not granted, you can file opposition. Anybody can file opposition. If you are saying, say, for example, your guide has taken up or your student had, done some cheating, then you can file opposition sort of thing. Or your competitor has done something, mischievously he has filed a patent before patent office, then you can file a pre-grant opposition. And after that, either it is grant or rejection, and then you can file within 1 year an appeal, and that can, or you can file the post-grant opposition that within patent office. Now, question arises, who can be the applicant? I mean, I'm not the university, I'm not the institute. Can I be the applicant? Yes, definitely you can. If you are inventor, you can. Then assignee of the inventor can file. He can be a natural person or legal entity, company, university, etc. We'll see actually how the fees and all differ, because we have made number of changes, number of amendments, I mean, and a number of times. So I need to give a little time for this. And even sometimes it happens that while a person has filed his LRs, I mean, legal representative, they come to patent office for filing this. And where to file, it is important to know, like for you people, this Delhi's office is the jurisdiction, because resident in India, this appropriate office is the place of residence or business or origin of invention. For non-resident in India, it depends upon the address of service which they have selected. We have decided or divided out like according to this number of states. If you can see the screen, based on these territorial jurisdiction, you are able to file your invention to one particular office. And then what are the type of application? What should I file in this application? For example, it can be an ordinary application, and it can be convention application, it can be PCT application, divisional application, or patent of addition application. Now, what is ordinary application? I'll show to it in a detail. What is convention application? See, Government of India has done number of treaties with other countries, and according to that, so even we grant the similar rights and privileges to their citizen as they grant to our citizens. So within 12 months, they can file any application which have been filed there in India, and will treat it as the same as if it is filed in India only. PCT, it is valid for a single application. You can go in a number of countries, and for this actually you'll get certain benefits. You get 31 months time to file the main application. And divisional application, sometimes it happens that you file number of applications, number of invention in single application. Then either the patent office itself says, or you yourself come up with a application and divide out that application. That is divisional application. And then patent of addition thing is there, that for improvement or slight modification of invention. So if you have already got a patent, or maybe you have got an application which is pending before us, and you again got certain improvement which you don't feel that it is a single application, then you can file a patent of this addition application. Then it is now a global world. You need to get a patent outside India also. Then direct foreign filing is not allowed. You need to take permission from India, or if you don't give the permission, then file within 6 weeks. If you don't do this, then you can be punished with a term which may be extended to 2 years, or with fine, or with both. Now, why it is so penal? Because see, it may happen that some foreigner can also come. They can, if we take a little sand also from here. I mean, number of, if I talk to in your terminologies only, these organisms are there. So how we can save this? So this is all this. Then the requirement of filing patent application, you need to fill form 1, and in that form 1 actually declarations are there, that who is the inventor, who is the applicant, and based on that we calculate fee, because all the fee is in proportion of 1:5. And then either you can apply through a patent agent. I will come to this, who are the patent agent. Then patent agents are the person to whom you need to give a power of authority, and it has to be on duly stamped paper. Then after this application you have filed, we will publish this application. Now, what are the benefits of publishing this application? Because this is like this. The publication is like this. In this publication, number of details are being shown, so that public is knowing that you have filed this application to the patent office, and with these many inventors, this is the applicant, and this is the priority date, this is the title of the invention. And actually you don't get any perfect right until unless your application is being examined and being granted. But the fact is, you are able to stop, or you are able to claim all the benefits from the publication date. So this date becomes crucial. I mean, if you go to the court, or somebody takes you to the court, so all the benefits which from the infringement suits are going to be decided will be based on this only. Then request for examination, this is not automatic. we don't examine all the applications until unless you made a request. For this we charge fee, and if no request is filed, we'll treat the application as withdrawn. Then all government offices are blamed like they are working slow, but we have made certain provisions for expedited examination. And for this, if you are selecting India as an ISA or IPA in the corresponding international application, or the applicant is a startup, then you can come up with this. Now, earlier you used to visit to the patent office. Now we have made changes. You can electronically file to the patent office. We need either cash or DD. And then for this e-filing, digital signatures is required. Fee concession is available for e-filing. If you file through e-filing only, we'll give you 10% concession. And if you are filing through agent, we are mandatorily making that they are filing through e-filing only. They cannot come to the paper form. Only if an inventor or university or somebody like that, they directly wish to file, they can file this paper form. Then for categories of applicant for the purpose of fee payment, if we say for natural person, for startup, for small entity, for educational institute, I will come to them, each of them. For them, we charge actually, if we say one, like 1,600, if they are filing through e-filing. And for other alone or with natural person, startup or small entity, for them, they need to pay 5 times more. So 80% reduction in fees is for them. Now, to boost up startup culture, actually government has decided that we will be giving certain benefit. They can come under expedited examination, and provided they meet certain things, like here it is mentioned, if they are private limited company or registered as partnership firm, but their setup should not be more than 7 years. It should not be old more than 7 years, and they should be towards innovation, development, deployment, or commercialization of new product, processes, or services driven by the technology of this IPR. And advantages, they have got reduction in fees, though they are company, but still they have been given reduction in fees. This is very essential for boosting them, right? And then if they have already filed a request under ordinary route, or anybody has filed, it can be converted to the expedited only. Then expedited have got certain benefits. Here the FER is issued, that the first examination report is issued within 3 months from the date of request of the examination. It is very good for them. And now again we have made amendment to this expedited examination number of times, and a number of entries now have been added to this. For example, ISA, IPA we have already seen. Then startup we have seen. Then the small entity has been included. Then if one of the person is a lady, female, now if any lady sitting, any lady inventor also sitting there, any lady student, any female student sitting, they can understand government of India is giving benefit to them if they are inventor. I mean, if they become one of the applicant, so they will be given benefit. Their application will be examined early. Then if it is a department of government, or any application is institution established by the central, provincial, state act, which is owned or controlled by the government, or it is a government company, or is an institution wholly or substantially financed by the government, or it is a sector which is notified by the central government on the basis of a request from the head of department of the central government, provided that the public comments are invited before such notification. So we cannot add any new department until unless we do this. Then we have got PPH, that patent prosecution highway with foreign countries. We have limited certain number of applications we'll be receiving, and we'll be examining them on the fast track basis. This is a very new amendment on 21st/9/2021 only. This is for private as well as for public institution. Educational institution, any Indian institution, if universities established or incorporated or under central act, a provincial act, or a state act, and includes any other educational institution as recognized by an authority designated by central government or the state government or the union territory in this regard. So I think this university of yours will be also covered in this, and so you can claim the benefit of 80% reduction. You can come with the early expedited examination. Only thing you need to innovate and come to the us. Now again, we have introduced a new concept of facilitator. They are the startup facilitator. They are patent agent of the attorneys, trademark agent, and the attorneys. Their list is given on our website. So you need to select on the basis of a particular field, like you are from agriculture field or something like that. So based on that microbiological field, so you will we have given their expertise, they are expert in this field. So select that from there. They will file on your behalf. They will not charge any of their professional fees, but however, the fee for application, the fee for request for examination, fee for hearing, or any other fee has to be to the patent office has to be paid by the applicant only. Then for MSME, if they fall under these criteria, this is a definition from there only. We give them early expedited examination benefit. For example, when this patent has been granted to one country, one company who have filed a request, and from 113 days we have given this patent to them, and after 264 days one startup was given patent on this date. I'm having this 10 minutes. So this is a little bit about patent specification. See how they look. I just wanted to show to them, show it to you. I mean, this is whatever you write is for public, whatever you claim is for you. If we see the left side, it claim is for you, whatever you write, disclose, that is for public, so that public know that this is your boundary, they don't enter into you, and you know what you are claiming, and everyone knows. But see, there are two types of specification. One is provisional, another is complete. And once you get an idea, you can file a provisional. So you get an idea of what you need to file in this, and then you get extra time. Actually, it's 12 months time, so that you further develop your invention, and you can avoid further expenses. If you decide that there is no commercial feasibility, so then you don't file this. And then complete specification is there, but difference between two majorly them is it is complete, and you must have claims here. So these all are the contents of complete specification: title, your field of invention, background of invention, advantages, summary, statement, detailed description of invention, working examples, claims, etc. And now claim, actually it is not that we are going to give you something like somebody say that they may ask that that these are the advantages of your invention. These statements are not to be the part of claims. Here only we are talking about all the technical things only, the first claim and the other claims. And this is a format of claim actually. And actually few things, like somebody may ask that we want this much money from patent office, we have done this. Sorry, we don't grant any money to you. This is between you and your commercial party. And then somebody says that this device is better and more effectual than other device. No, it is not like that. So we will check and then decide. I'll just show this, like these sort of drawings are there for you need to prepare drawings if drawings are needed. And then this sort of specification is there. Here you need to give address, then preamble and all. Then first paragraph is field of the invention, then second is background of the invention, how you come up with that. Field of invention, I mean the field which you are dealing with. Then disadvantages of the prior art which prompted you to make this invention. Then summary of invention, then advantages of over prior art, then the statement of the invention, then brief brief description of the drawing, then detailed description how this invention is working, and then finally you write claims. In claims, you will describe all the essential features which are so integrally connected. You write before us so that you are able to write protection for you. Now, this is a PCT system, and here you get a time period of 31 months. If you see from left to right, it is 31-month time. Here, this you are able to decide in these countries I am willing to go. And actually later on also you need to pay fee there also. And if you get patent from us also, then what are your duties? It is not like this that you will be going to get something from us. You need to pay renewal fee to the patent office every year. And if you don't do this, we can issue compulsory license to that. Then this calculation is there, renewal fee is there. First 2 years are free, thereafter we need charge. Now then, opposition to the grant of patent is there. We have introduced two types of opposition. One is pre-grant and another is post-grant opposition. In grounds are same, which are wrongful obtaining, prior publication. For example, we miss any of this, then you come to the patent office citing that these are the things actually you should look into this, or somebody else may come up to for your application that why don't you look into this and refuse a patent to them. Then we act as judges, patent office controllers. They hear both the parties and give final decisions. And then post grant, this can be done within 12 months from the date of publication of this. Then role of patent office, like I have already conveyed many things. Now we are working as IAC and IPA also, and we grant compulsory license also. Then revocation also. For example, some wrong patent is being granted, then what we can do? Then patent is being revoked. It can be revoked by the controller of patents, by opposition from person interested, or by the central government or non-working of patent in India, or by the High Court, by the petition of the interested party, or by some specific ground, or by the central government if it relates to the atomic energy substance, if it is not in public interest. So it is so watertight. I mean, if something wrong happens in the whole process, then it can be taken care of. And then compulsory licenses are there. If after 3 years from the grant to the interested party, it can be granted, but it is granted on very limited ground. For example, reasonable requirement of the public with respect to the patented invention have not been satisfied. For example, we need 10,000 doses of a device, of a drug, but the company is able to provide us only 200 devices. And that it is there. Then it is not available to the public at a reasonable price. For example, they are charging 2 lakh, but it should be available. We decided maybe provided a price of 10,000 in that case. For example, patented inventions not worked in India. We want it to be in the tier 2, tier 3 cities of India, but it is available only in metro cities. This has probably happened in this the case of a cancer drug case, where weekly expenses were 2 lakh, but we got from Natco Pharma, they said that we'll be making this drug for around 8,800 or 6,600 weekly basis. So we granted a compulsory license, but it is not, it is that it can be easily granted. It is very tedious process. And again, it can be given in national emergency, extreme emergency, and public non-commercial use. Then, like I suggested, you even few of you can appear for patent agent. They assess the inventor and applicant in patent drafting. Now even Delhi High Court has allowed them to appear before them as an advocate only. So they are not advocate, but they'll be treated as an advocate. And definitely for discussions with the examiner and hearing, and to assist the inventor and applicant in filing the patent application, they are there. Then few new rules I just wanted to highlight what we are doing. We have cut down our time limits. Earlier response period was 12 months. Now we have cut down it to 6 months. So if you have filing application, you need to be hurry up, like we are doing this. And only thing is it can be extended up to 3 months. Earlier it was only 12 months. Now it is 6 months, either 6 months or 6 plus 3 months, 9 months. Then all the hearings are through video conferencing. You sitting at your place only can do your hearing, whatever, whenever we are inviting you, if there is any objection to your grant of patent. So you need not to rush to the patent office. Then earlier, what we used to face that many adjournments were coming. Now we have restricted the adjournment list. So, and now again, you need to file your reply after hearing within 15 days from the date of hearing. Then claim deletion and national phase from this applicant side only we have received this, that we should restrict it. And this claim, for these claims which they are deleting, we should not ask fees. That's why we are okay with this now. And now, like we for sequencing listing, maximum fee, official fee, we have limited to 1,20,000. You may say why this is this much. See, we have received in lakhs. I mean 10 lakhs, 20 lakhs also we have received fees. So this is not so less. And then refund of examination fees. If you are deciding that we are not interested to file the examination, then your this application can be refunded. 90% of the fees can be refunded, provided you file a form 19 and request for this withdrawal. This is again your expedited application, and timelines have been given here. Now, electronic submission is mandatory. Now, electronic submissions are mandatory for agents. And all the filings have to be done at online portal only. and an address of service and email address has to be definitely given to us. And these are the documents. Even if you submit online, then these are the documents which we need in physical. I mean, hard copy of these documents. And if you file a physical mode, then we charge 10% more from you. And from 1st April 2016, auto allotment of applications is there. For example, I'm sitting in Delhi office, but maybe I'll be accepting any application which has been filed in Chennai office or Calcutta office. So it is on random basis. It is totally transparent office, virtual office it is working. So nobody knows which application is going to be going where. So I mean, if you even file application from Lucknow to Delhi office, but you will not be knowing that where your application will be going in for either of the 4 offices of the government of India. So, and then if there is FAR will be coming to you, then hearing letter again will be coming, but all this will be coming by email only. And from July 2017, now we are issuing patent certificate also by e mode only. So these are the 2 websites which may be useful to you. I suppose whosoever is participant, if they are interested, they may note down ipindia.nic.in. And then another one is this WIPO website, wipo.int. And so this is again our in-pass. We have in-house developed this, and in this you can search. This is very dynamic sort of thing. I mean, actually our website is very dynamic. You can come to know which application is being dealt at and which application is at which level now also. And in this application, I mean, in this impasse, you can search with your title. Maybe if you know that who is the applicant, if you know that the applicant is another university, maybe MIT University, you want to put them. If you know the inventor name, inventor is Indira Gandhi or Priyanka Gandhi, you put her name. If you know inventor country. So with this all, you can know actually whosoever is in your competition. And so these are all free sites. If somebody is interested, they can note down USPTO and JPO and EP site. And then there are many other paid sites also, because before filing to the patent office, you must know that what are the advantages, whether I'll be getting patent or not. Then, like I said, IPAP has already been abolished. Now, many cases have been transferred. And in fact, all the cases have been which were pending before IPAP have been now transferred to high courts. And even our national policy also suggests for this commercial courts, commercial division and commercial appellate division of high court. And IP divisions they have already created, and they will be giving us the speedy and time-bound trials. For example, we have seen in these cases. So this is all actually, I mean, this is procedural part. It's quite a bit lengthy also, but there are a number of being developments. That's why I wanted to cover all these. I mean, I was maybe in a little hurry only, but see, we are getting definitely good patents from, I mean, in all fields. Like if I see this food also, I'll end up this presentation with one this example. If we see this cup noodle thing, that ready to use or the ready to use food. So this is all, I mean, food technology, good inventions, marvelous inventions. If we are traveling abroad or somewhere and we are using them. So, and every invention is like that only. So I'll give you, thanks for your kind attention. I mean, I was in a little hurry because I wanted to cover a lot. That was my concern. At least so you come to know that these are the things where office is dealing with.
Thank you so much, Mr. Sharma, for the detailed registration procedures you really discussed in detail. And I believe there was some question some time back. I'm unable to see in the screen, but it was related to like, why is there this time duration that a patent is granted for 20 years? And similarly for others also, other categories. See, it is a bargain between government and a public. So we cannot grant it in perpetuity. I mean, it has to come down sometime. And even the MNCs, what they are trying to do, they just want to, I mean, through their tactics, they want to linger on. But it, like our country is a developing country. We or even all countries, they have got their own agendas and all. So it is discussed at international forums. What is fine with you? For example, I mean, if I talk with you, like drugs case, it takes lots of money to develop a new molecule.
they want to have extension of their life for drugs life. For example, we take 5 years to grant this patent. Then in certain countries, they are saying that why don't you extend this 20 years life? So I mean, this is a very basic thing, but it is a bargain between government and public. They are disclosing their thing, then we are giving them this right for 20 years only.
So
Now, why
does
20 in particular? This has been devised out and at a number of international multiple forums. Why it should be 20? It should be less than I mean, if I give you the example, when I joined patent office for drugs, we were giving a patent for 7 years. For this instruments, we were giving patent for 14 years. I mean, like I did law also. I tell you honestly, this is very honest confession actually. What happened in one particular case, that was a syringe that we granted believingly that this is an apparatus, this is a needle for 7 years. We found that invention is there, but the person read from Drugs and Cosmetic Act, and where it is written that if any object is used for intramuscular injection, it is a drug. So he came before us and he said that no, this is a drug. You should give a patent for 14 years, not for 7 years. So I mean, different things are there. Drugs and Cosmetic Act, it was like that. But now we have got a uniform 20 years of life, for at least for patents. But a number of things are being raised. But this time period is not this that which has been coming in a single day. It has been deliberated number of times. Then only it has come up. All these timelines. I think this makes sense, Rahulji.
So does this mean that it needs to renew it within?
Yeah, they have to
before
renew it.
lapsing
They
of
have to
that
renew it.
period?
Can you come up again, please? Hello.
So thank you for your discussion, Mr. Sharma. It was really good to know all about the registration procedures and all. So I believe we don't have any more questions.
And if any are
So
if
in
any
case
questions
if we
are
don't have any more questions,
Rahulji, if any questions are unanswered, they can email me also. I'll try
Sure,
to
sure.
solve them. I mean, I have given my email ID also, so we'll try to solve them.
great. Thank you so much for this involvement in this session.
Okay, then thank you.
Thank you. And the Dr. Sheetal, are you there on the line? Arnav?
Yes, sir.
I believe Miss Lohita Sujit has
Sir, yes, sir. I just received a call from Miss Lohita. There was some emergency. She said I'll be 2-3 minutes late. She'll be joining in 3-4 minutes.
Okay, so do you see any questions now?
Sir, I saw 2 questions, one from Mohit and the other one you asked, sir. The question was why copyright or patent right gives you particular or specific.
Exactly.
No, sir. Only 2 questions.
Exactly. No more.
So students, if you have any other questions, you could ask. Sir will be happy to answer all your doubts.
Otherwise, what can be done is any questions pertaining to this session may be sent to IPTSC. IPTSC may collate the same, all the questions, and send it to us.
Absolutely, sir. I'll post my email. I'll post IPTSC's email ID in the chat box. And if students have any questions, they could send it to us on mail, and we'll be happy to in turn connect them to Vikas sir and you, who can answer their questions.
Exactly. Why I don't want direct mails to Mr. Vikas Sharma is that there will be umpteen mails, and then confusion will occur in.
No problem, sir. So just give me a minute. I'll post the mail. Students can then.
Rahulji,
can we have Mr. Shiv Puja's session before Ms. Sujit session? I believe Mr. Shiv Puja is already on the screen. I could see him.
Rahulji, I just wanted to know if I can ask a question to Vikasji.
Yes, sure, for sure.
Hi, good.
How are you, Vijay?
All well, Vikasji. Hopefully you are all well. Like
Yeah,
you know.
we are good.
Vikasji, I have this one question with respect to the recent amendments in the fees actually for the academic institutions.
Yes.
And like you know, the fees has been reduced basically. So but then I think the academic institution, what kind of proofs the academic institutions need to provide like you know, for being eligible for that particular scheme?
It is written there in that rule, which has been passed on September 21.
Yes, so I mean, any affiliation to the university or the academic body would be sufficient, right?
I think so.
Yeah. Okay. Thank you. I think Loita has already joined in.
Yeah. Okay.
So Loita ma'am is here.
Okay, Miss Loita, we cannot see your image, so video.
I was waiting for the for Vijay to finish. Am I visible now?
Yeah.
Yes,
yeah.
you are visible.
Hi Vijay, how are you?
All well, Loita. Hope all is well with you.
Yes.
So, Miss Lohita Sujit, we welcome you for this session and today's program.
Thank you.
Miss Lohita Sujit is the Senior Director, Copyright and Digital Economy, and she is with the Motion Picture Association. And she would be taking a technical session on dealing with copyright and trademark infringement. So, session is all yours, Miss Sujit.
Yes, I just need some screen sharing permission.
You must be already having, no?
No. So I think somebody else is sharing a screen, so that's why. So I think Vijay, I think you need to stop sharing. So
yes.
So Vikas sir is sharing the screen.
Okay.
Vikas ji is there?
Yeah, he's on call.
Still?
Yes, sir, he's still there. I think he forgot to disconnect the call.
Just But you can start sharing the screen. That will automatically stop Vikasji's sharing.
Yeah, I think this is fine. All right.
Right?
Sure.
Great.
It's visible, right?
Yes.
Okay. Good afternoon, everybody, and thank you, ICC and IPTSC, for this opportunity. I did have a word in the morning with my colleague from IPTSC, and he said that this is a mixed batch of students. So we are going to deal with a technical subject today. It's called enforcement of copyright, and I will touch upon the trademark infringements. You all can always read about it, because otherwise it would have extended the timeline. So I aim to finish it within the hour or before the hour, so we are open to questions, right? So I'll begin by speaking about my company. We're the Motion Picture Association, and we represent 6 Hollywood studios in India, which include Universal, Warner Brothers, Disney, Netflix, Paramount, and we work with both industry stakeholders and the government to not only help better the framework for enforcement in India, but literally actually even grow the media and entertainment industry in India. So I'm sure there's no better time than the pandemic to really talk about our industry, because I'm sure most of you all are plugged in, wired in to different screens that you possibly have access to watch many programs. So let's start by talking about the general impression about the industry. And I wanted to talk about this today because we're dealing with the subject of content protection and why we really need to discourage any form of infringing, with regard to copyright. So the general impression with regard to our industry is that it's very glamorous. There are huge, monies to be made, and so what? It's okay if someone shares an illegal file with me. Why don't I just watch it? But what people generally don't know is that behind every film, and I'm talking about not just your favorite web series or your, a cinema that you watch, but even a small piece of content like a short film, which you today can watch on Hotstar and various other platforms, or even a documentary, is dependent on a blue carpet of artists, technicians, and daily wage earners. What we mean by this? We mean by this the fact that for every film that is made, you need to have a set, you need to have carpenters who probably are working on that set. There are various types of technicians. There are various types of, talent that we work with, including choreographers. There are daily wage earners like your spot boys, camera workers, etc. And every time a film is copied, the revenue that the producer earns or the banner earns reduces to that extent. When that happens, it affects the daily wage earners. And this is very, very important to understand when you look at the media and entertainment industry, because every action that, or any adverse action that happens, affects these people that you're currently seeing on screen. Let's look at the potential of this industry. I thought I should put this out there for you guys, not just to bore you with numbers, but to really tell you all that this industry is booming. It's a great time, no matter what you're doing, to look at a career in this industry, be part of it, because it contributes not only, to the economy. You can see $49.9 billion there. This was the contribution in 2019. I'm sure it would have increased, but this was the last study we did, and we supported 2.6 million jobs, which is absolutely fantastic, because when you look at jobs, we're not looking at high-flying executives. We're not looking at people working in management, jobs. We're actually also looking at the daily wage earners. So it's a great time to be part of the industry and also encourage this industry to grow. So I don't know about how much the earlier speakers covered, but I thought we must talk in a, please feel free at the end to ask me questions. I'll try not to be very legal. But you need to understand what copyright is. But before you understand what copyright is, let's kind of think of a very open concept, right? Which is an idea. In whatever you're doing today, maybe some of you all may write poetries on the side. Some of you all may make some music, or you all have made even a short film, maybe for your college assignments or just for your hobby. So every time you have an idea which is unique and you express it in a form. So if you look on the right, literary means anything that you put in writing. So I think the closest we can say to that is the publishing industry, when people write a book, or you publish something in writing. Music, of course. Artistic could be a wide range, which also could be sculptures, etc. Dramatic, obviously, most of the works you see on screen today are dramatic, but it also covers theater. And of course, sound recording. So by recording, we mean sound recording. So what is copyright? Copyright actually is any work, anything that you do today and whatever you represent in an audio-visual format would include a bundle of rights. So it would probably have some music in it. It would definitely have a script, because how would you even shoot without a script, right? You would, if you included some kind of a song, then you would have lyrics, the lyrics to support it. So which is why we say copyright is a collection of rights which enable the owner of copyright to do the following things. Now, what does this mean? Imagine today you have an idea, whatever you're doing. You may be a student, you may not be even related to this industry, but you put an idea to expression by making probably a film. Now, this should grant you some amount of rights. It should give you some amount of protection so that nobody else copies this work from you, right? So the right holder, the copyright owner, can or is the only person who can allow the copying of the work, which means reproduction, issue copies, which means distribution. So for example, if you make a film, then you have the right to distribute to whichever cinema, whichever market you want that film to release, right? Communication of the work to the public, obviously bringing that film to screen. So you have the right to decide when you want to release that work, translation, adaptation, etc. Right? And of course, to summarize it, therefore, as you can see on the right from the image, copyright is a collection of rights that govern literary, dramatic, musical works in addition to books and computer programs. So computer programs is basically your software. We will not cover this today, but I'm open to questions at the end of it. So why do we need copyright? And I want to emphasize that this is very important to inculcate or encourage a creative economy. If today we have an environment where anybody and everybody can rip off someone's work, you take somebody's short film online, you make it into a long film, you make it like a 2-hour film based on that idea, or you probably, you rip off someone's tune and you make a different song out of it. What really goes wrong? First of all, in my opinion, having a right like copyright is a very positive right, because it enables you to not only create more works, but it enables you to also monetize. So it is a way that you can, fund a living. You can, most of the studios today, if you see, say a studio like Disney, they are monetizing their copyright, not only through their films, but also through the merchandising. I'm sure all of y'all would have some Marvel or some Star Wars merchandise that y'all would want to buy. They do have theme parks. So it's an ability for someone to take a simple idea. So if it's Disney, it's a simple idea like the Mickey Mouse, or it's a simple idea like any of your Marvel characters, how they've really taken that expression from the film to a longer pipeline, where today there are theme parks and there's merchandising and there is all sorts of items available where they are just monetizing on that single idea of a character, right? And the other aim of the copyright law is also to balance. So at the end of the day, the law is amazing because it not only balances the rights of the people who create content, but it also gives you a public right. So if you look at, say, books, for example, right? So in educational institutes, you are now today, according to copyright law, you can access the library, and there are open libraries where you can use those books for your studies, etc. Now, coming to, because our topic is copyright infringement, let's look at what is copyright infringement later from a technical perspective, but I want to cover it in a very short word called piracy. This image here looks complicated, but I want to start by giving you all a preamble pre-COVID and post-COVID, right? So pre-COVID, most of the films released in the cinema, and there would be instances where a person would record these films in the cinema using, say, a mobile device or a camera device, and immediately it would then spread on the internet. So on the day of the release of the film, you would find it all over the internet and people could access it in various forms. And, we do interact with a lot of young people in many workshops that we do, and people mostly say, we had exams or we can't see that film, and, so what? Now, the reason for this complicated diagram is not for you to understand who these, I'm not expecting you all to understand what each of these pyramid structures mean, but I want you to understand this is a serious organized crime. This is an organized crime where somebody records something for a purpose. That content is recorded and it is circulated among various aspects of a crime economy. So if you look at, on the right, you will see a word called release groups. So release groups, facilitators, file sharers, these are all people who work with the pirate syndicate that actually acquires the content. The content need not always originate in India. They could have been recorded anywhere in the world. And this is pre-COVID times when OTT was not there. Now it's even worse, and we'll see that later. But this diagram is basically to make you understand that as a consumer who watches content, as a consumer who probably innocently or intentionally downloads a pirated content, you are the least common denominator. What really is the crux of the problem is the top 3 layers of this pyramid, which is basically, in a way, you are supporting organized crime. And we'll see how that is in the consequent slides. So first of all, to give you an example, this is how a normal website looks like, a pirate website looks like. And in certain age groups, when we do research, we find that people don't even know that these are pirate websites because they're very well organized. If you look at this website, it has regional content in it, animated content in it, and people mostly get confused. They think that, okay, this could be a legitimate website. So most pirate websites try to imitate legitimate websites, and very little possibility for you to know that it's a pirate website. But today you have the discretion to know that a film has released in theaters. You have the discretion to know when you turn on Netflix, this is a new show. So if it's a new show and it's on a website like this and it's not on Netflix, you should obviously know that it's a pirated website, right? Let's look at what are the 4 types of websites. This is very good to know because mostly consumers are dissuaded. They do not know what a pirate website is. So sometimes when you type a particular name of a film that you want to watch, it would probably take you to a link, and then the linking site puts you onto another website where the content resides, which could be a site like this, right? Peer-to-peer, I'm sure most of you all know, this is basically through BitTorrent, etc. There are hosting sites which also make a lot of money. So these are the sites where the content originally resides, and then they could be possibly catering to linking sites and peer-to-peer content. And of course, cyber lockers, which are the, there's a whole network of cyber lockers worldwide where only pirated content exists. Now, because we are in COVID, which is why I said pre-COVID and post-COVID, all of this is accessible to you at literally a click of a button. You have apps like Telegram. So I'm not going to call Telegram an infringing app. I'm trying to emphasize here that today technology has modernized to such an extent that your ethical channels, probably your Facebooks, your, apps like Telegram, there are channels here which are sponsored by pirate, operators like Tamil Rockers. So Tamil Rockers, if we look at the amount of millions and millions of dollars that they've made supporting the pirate economy, they are probably the ones who are making channels on such apps, and then it's distributed to consumers, right? And I'm sure, I don't know if any one of you all know, but they also have Facebook handles. They have all sorts of social media handles to direct people to their site. So which is great. I mean, on one hand, one can say, great, I'm getting to watch what I want to see. Maybe, I'm just 1 or 2 consumers. Me and my friends are watching this content. So what? So this is why you should care, right? Every website, every linking site, whether it's even a channel, say on Telegram, that is showing you pirated content today, funds a crimeware economy. And this is from a report which is actually quite dated. I'm sure they're making more money now. This would date back to about 3-4 years, where a company called Digital Citizen Alliance did a report. And what you can see here is for every activity that happens on a pirate website that distributes movie, the pirates are making money. So I'm going to read two of my favorites because these are the most abused ways. So if you look at a malvertising campaign, or let's look at, installing malware or virus on computers. Every time they install a malware in the computer, that is the kind of money between $25 to $500 is what the pirate syndicate earns, right? $50 to $200 is the pay rate for 1,000 installs for a malvertising campaign. Now, what's a malvertising campaign? So basically what they would do is show you a content you could download and then probably take you to sites where you are suddenly now in a place where you can, you're exposed to either adult advertising or drugs, or possibly even games which are not really legitimate games. And, I wouldn't say that they're games that your parents or anybody would approve of. So this is the kind of activity that gives them more money. Keep in mind that these activities are additional money that they're getting apart from the viewer downloading the content. So when you download the content and view it, they're anyway making a lot of money in that. And this is the additional money. And this is really the crux of what piracy is and what content protection is and why we are talking about copyright enforcement today. Right? Let's look at some of the other negative impacts that pirate websites and any piracy, operator can take advantage of. Obviously, most of these sites, sometimes innocently, they would ask you to create an account. So there will be personal ID theft. Right? We have seen cases in many territories where when it comes to small and medium enterprises, smaller companies who probably somebody would have used their computer to download a movie. We've seen cases of ransomware where probably the small company, because obviously they cannot afford very high-end IT systems to protect their network. There have been cases where their site is completely locked and the pirate has threatened that if you want the information back, then you need to pay us a ransom fee. So this can come down from a larger society perspective to also you as an individual, where probably your credit card can be stolen, probably some personal information can be stolen, not to mention your computer being hacked. And this is something that we all need to be mindful of. So Game of Thrones, it's obviously distributed by HBO and it's one of the hot favorites. I'm sure most of y'all would have watched it on Hotstar. So the final season in 2019 was obviously heavily pirated. Not that studios do not take enough precaution, but the crimeware economy is such that they want to get the content before the studio even puts it out most of the times, or it's just released, they want to hack it and distribute it. But all those distributions had 9,986 torrents. And there was an attempted 1,29,819 attempted attacks of installing malware into people's computers. So this is the impact of just one program, which was Game of Thrones. Let's look at, this was a very, very famous pirate syndicate called Kick-Ass Torrents. The reason for mentioning these numbers here is to give you all the extent of money and profits that these pirate sites make. None of this comes to the consumer. None of this goes to the government. So definitely this is a parallel crime economy. It's also a very bloodless, there are victims in terms of probably cybercrime, but it's the easiest way to make money probably would be, pirating content. And this particular site was, minting money. And by the time it shut down, it already had a net worth of $54 million. So this is the kind of money that the pirate websites are capable of making, and with zero benefit to the consumer or the economy. And in fact, if not anything, a lot of harm to the consumer because of all the theft. Let's also look at, how India fared. So in a study that we did 3 to 4 years back, the top websites that offered stolen content, they generated, so this is basically the figures in COVID time. So this is the kind of money that the top websites generated, 1.8 billion in global ad revenue. The top apps that stole content generated 259 million in global annual ad revenue. These are very important subjects. And if there are any researchers today or academicians today in the audience, I would urge you to look at the negative impact on this on the economy, especially during COVID when people are, people's jobs are at risk and we want to create more growth opportunities in every sector. Now, when it comes to, if I were to compare the money that the websites make vis-a-vis the studios, what you need to understand is every time a film releases in the theater, or probably even it's on an OTT channel, there's money to be made, but in theatrical, you really do not know how many people will like the film. So probably your movie will be on screen for 2 weeks, or maybe sometimes even 1 week or 10 days. And when the pirate copies get out, that much money is obviously lost by the content owner and the producer. And I'm talking about small producers or local producers of regional content. And when the monies invested by these owners become less, then it has a direct impact on the jobs of the people who are working in the industry, because if there are lesser projects, then obviously there's going to be, if there are lesser projects to invest in, there are going to be job losses. So as I was mentioning earlier, we did do a study with FICCI. It was called a Badvertising report. And this was a report which had great significance, because for the first time in India, we realized large pirate sites made up to 4 million annually, right? And we're talking of US dollars here. Medium and small sites made $2 million. And we also realized that sometimes the intermediaries, so, you today, when you want to look for content, you directly go to Google. You directly go on a search site. And when you go on these search sites, they obviously take you to certain websites. So DoubleClick, Pop Ads, these are intermediaries where, they are softwares owned by probably the likes of Google that take you to a particular site. And mostly they were the top of the list for guiding consumers towards pirate sites. So this was a very interesting study. So for researchers, there have been very, very big studies on the impact of these intermediaries and why countries need to take stronger action to stop these intermediaries. Let's look at the impact of piracy in the pandemic. Like I mentioned earlier, everybody was glued onto screens. Everybody was working from home. It was a great opportunity for content companies to generate content, but this has also been a time where there has been a lot of piracy in India. So according to the Edeto research firm, in the Indian media and entertainment industry lost about 2.8 billion of its annual revenue to piracy during the pandemic. And a single show by Hungama Digital, which is damaged, had over 169,000 downloads across different torrent websites. We never measured the impact because it's difficult to calculate malware in those torrent websites, but that's the kind of impact a single program had. Now, what would the impact be if you had a company, you've spent months and, probably crores of rupees making content. You're putting out that content today. Unlike the theatrical, like I was mentioning earlier, theaters, they have release dates. So Thursday, Friday, your movie releases, audience decide how your movie will do. But when it comes on the online side, but the minute we're looking at the Hotstars and the Netflix and the Hungama Digitals of the world, people have to, everybody should understand that the content there is accumulating over a period of time. And while they do advertise their shows, they also leave it for people to explore content. You would have watched a new show, you want to watch something else, you continue to be on it. Now, they cannot afford to have piracy because it's a discovery process. And over a period of time, they have to continue building their bank because they are huge platforms and they depend on thousands of hours of content. So the figures for this show Damaged are very disturbing, and it will have a ripple effect if it continues in the years to come if we are not mindful of our laws and we do not take action. Not to mention, India is among the top 5 countries in peer-to-peer downloading. Right? Overall, we saw 30-40% consumption on video streaming, right, on illegitimate sites. We also saw that in India, there was a 62% rise in illegal watching of content during the pandemic. Now, because we're talking about enforcement, I think it's very important to understand what the law is today, what's the law of the land. And I won't get very technical. We leave some time, to discuss towards the end. But I will want you to, go through the act because that's really the best way to, understand. So first of all, the Copyright Act pretty much protects every aspect of the media and entertainment industry, right from your music. So today, if you download a song illegally, yes, you have rights of protection, copyright. You download a film, obviously you do. But what I wanted to what I want you to understand that there is a strong act today which protects musical works, and you have the right to take action when your content is illegally stolen or you find that piracy has happened. Now, what is infringement? Because the topic that I had to cover, I think it's important for you to understand what it is. So first of all, authors create new work and enjoy copyright protection and can monetize their work. So as I mentioned earlier, I think in the beginning of the presentation, if you make a work, you can distribute it, you can license it, you can, give it to sell it in different territories, and you can make money out of it, right? The owner, which is if you've created content, only you will have the exclusive authority to sell your work and to give a license. Now, why is this important to understand? It's very important to understand that your rights, because tomorrow somebody can easily copy your film, make it into something very similar, or rather without your permission, license your work, you would not even know. So it's very important to understand that understand your right before understanding how someone can infringe it, right? So in case if someone reproduces or duplicates the copyright work of the holder, which means somebody copies your film, your music, your sound recording, your lyrics, your script, it will lead to infringement of copyright. So any form of copying of any work, it's not necessary the entire film. It could, you could be a person who's written a script, you've registered your script, right? And you've commissioned work to somebody else lifts your script. That is infringement of copyright. I will not browse into specific sections because of lack of time, but I will look at specific. So in section 51, which is of the Copyright Act, the most important thing here is anybody who copies the work without obtaining permission. So anybody who does anything to copy your work without your permission, and anybody who distributes that work. So if you realize earlier, I covered how you get pirate content through apps, you get pirate content through websites, etc. So anybody who first steals your work and anybody who then distributes it illegally is said to have pirated your work, or when copyright is infringed. This is really the essence of this section, right? And if you really look at the definition of piracy, it's extremely simple. Any act by anybody without permission to copy a script without permission, telecasting a film without permission, remaking a film without procuring remake rights. This is very, very important because many times people say it's not really a remake of a film. I thought of it differently, but it doesn't work like that. The act is very strong, and even it protects remake of a film. Using another song in your movie, this is very important, especially for those YouTubers and people who are, making amazing content online. It's important for you to know this. Physical and digital piracy, I won't say it is really relevant. Yes, we are seeing a few instances of camcording where theaters, in countries where theaters have been open for a very long time, but this is not really our primary problem today, but it continues to be a problem. Uploading illegal copies, DVD rips, and this could be even, rips from web shows and web series. So that also applies here. Providing unauthorized link apps or devices from pirate aggregators. Like I mentioned earlier, pirate aggregators could be your linking sites, cyber lockers, etc. So these are the particular acts today that is protected by law, which is why I think it's extremely important for you to understand what comprises infringement. But it covers pretty much the whole gamut of what you cannot do. And if you do it, then it would result in infringement. Now, in terms of remedies, so there are legal angles. So we'll obviously look at certain provisions in the Act, and I'll try to explain it in the easiest possible way. But I do personally think that we need to do more from, from an industry stakeholder perspective. So what is a civil remedy? So civil remedy is probably when, when you go to dispute, when somebody say remakes your film without your permission. It's not really a criminal act. He's not yet put it on a pirate site. He's not installed malware, etc. So that really is civil remedies. I'm not going to get into the details. You all can write it down if you all want to read. But there are many civil remedies are available in the Act. If something like that happens, you can approach the court. There are many instances where probably, let's look at probably a case of, say, a folk singer. The folk singer in a village doesn't know what his right is. He doesn't know what copyright is. And out of custom, there are folklore and folk music that's happening. And if someone copies that work, right, that person does have a right to go, and probably a civil remedy then would apply there. Let's look at criminal remedies. So criminal remedies is really used when we're talking about these websites which are carrying infringing content. This is applicable where you, in smaller markets, say tier 3 towns, etc., or tier 2 towns, you see pirate CDs being sold. So the Act does give you criminal remedies where under various things. So to keep it very simple for you, the first thing is if you just copy a film, then there is obviously a punishment where you have 6 months and a maximum term of 3 years. So these are the punishments in the Act are deterring, but in my opinion, more can be done, because if you're looking at larger syndicates, and like we spoke about Tamil Rockers and Kick-Ass Torrents, they're making millions. So this is probably not the best deterrent for them, and we'll talk about how we can deter. There are remedies to even deter those, but to a certain extent we need to do more in terms of increasing certain criminal liabilities in the act. Section 63 to 65B so obviously the second section is that the act today gives you protection if the person does the same crime twice. So first, if you do it for the first time, there's a particular punishment. If you're a habitual offender, you're somebody who is, obviously you are a pirate, you're not someone who's gotten innocently, and you keep doing it the same thing, the act protects you. And there are a lot of cases where I'm sure you'll have heard of watching content through VPN or hacking devices, or there are devices today available. They're not become very popular, but they're called infringing devices, where you can pretty much buy the device and there are illegal apps already downloaded on them. So there are illegal apps of, say, of any like an Amazon Prime or a Hotstar, etc., already embedded in these devices, and consumers may not know that, but they are making millions of dollars by selling these devices. And once connected to the consumer then does not sometimes even know he's watching these apps illegally. So the act is quite robust, and it even protects these acts. So of course there are other remedies in the act, which is basically if you're using infringing copies of a computer program. So this has to do more on the software side. So sometimes if, say, in a smaller company, they do not use licensed software, which you're supposed to use licensed software, because the software company has invested millions of dollars in research to create that software. So the act even protects that. And it of course protects, or rather it has punishment for even possessing an illegal copy or possessing a pirated work. So it's a well-rounded act in that sense. Now, as I was mentioning earlier, we do have a law, we have enough protection in the law, but why do we need more? We need more because today piracy is not just an Indian phenomenon, it's a global network, it's a global network of syndicates. And in addition to strong copyright legislation, there have been a lot of efforts worldwide. So, the first effort, I would say, and this has kudos to both the government and the industries. Today, you can watch content either free, right? A lot of your online content companies today give you free services. Part of the content is free, and then if you want to upgrade, you can upgrade to as less as 50 rupees per month. So the first thing is increasing the number of legitimate services, which I think are available today in India. This is also a very good way of educating people. So in earlier days, when there were no OTT platforms, there was just broadcast and theatrical, we would say, fine, wait for it to come on TV. But today, that's not the case. At a very, very low price today, you can watch legitimate services. And even the platforms which are giving you slightly expensive content, there are various, like Netflix also gives you a very, very affordable plan if you just want to watch it on mobile. Enforcement action, this is really to do with the police. A lot needs to be done with respect to enforcement action, because you have a law, it gives you protection, you have legal services, but a person who has pirated, say we catch hold of a syndicate, I'm not talking about consumers downloading content, we're not talking about that. Say we really did do a good investigation and we find the syndicate, we need proactive police action. And we see that in many states in India, leave alone understanding intellectual property rights, they do not understand copyright. They do not consider it a heinous or a serious crime, because most police stations today are dealing with crime which are much more heinous than that. They're dealing with murder, they're dealing with a lot of other crimes. And therefore, there's a very immediate need to have IP focused enforcement action, maybe have cells in the country, maybe have nodal zones for these, but this is very, very important. And we'll come to commitment from local stakeholders, where I think as a representative of the media and entertainment industry, we are equally responsible for protecting our content, and how, various territories have done a great job at it. So first and foremost, let's look at legislative action. I want to inform you all about a phenomenon called site blocking. What is site blocking? So site blocking is essentially, if I want to release a film or I want to release a web series, I can pretty much go today to the Delhi High Court and I can, file a petition which says that these are the lists of illegal sites. Please order that they be blocked. So once they are blocked and my film or my content releases on whatever platform it is, it will not be infringed. Of course, it continues to infringe because domain names keep changing, but this particular law has given us great results, and it's amazing that we do have this particular law even in India, but it is subject to the orders of court. So you will not find it in the Copyright Act, but it's a great phenomenon and which is today supported by so many countries, as you can see on screen. Moving on, I want to talk about cross-industry collaboration. So as I was mentioning earlier, there's a lot that we as industry can do, and representing the media and entertainment industry, we can work directly with these 4 or 5 components which contribute in a way to a pirate network. Let me explain how this works, right? So if there's a particular website and I want to take it down, I can always go to the hosting provider. I can always go to, say, a GoDaddy or wherever it is. And if there is some kind of a voluntary arrangement, then those hosting providers have cooperated and they do take these websites down. Online advertisers. Now, online advertisers are important because today when you go on Google or you go on any website, you see a brand advertising there, right? You go on Instagram, you see brands advertising there. Even on websites, probably sometimes you're browsing through websites, you can see somebody advertising a shoe brand or, asking you to buy something. Now, the minute you educate the community that puts these ads on the websites, so you tell them that, listen, when you put your websites, because of intermediaries, like I explained earlier, like Google AdSense, etc. These are intermediaries that work on algorithms. They're just they're software. They don't really always understand where your ad should go. So sometimes what happens is, when I'm a brand, say I'm Parachute, or let me say that I'm Samsung, right? I want to advertise online. I hire a media agency which comprises the online advertising community. And that media agency puts out my ads across X number of websites. And probably as a brand manager, I just get a report which says, okay, Lohita, your ad was seen by X amount of people. Now, most of the times, these ads unknowingly or inadvertently appear on pirate websites. Now, that has a dual impact. One, if a consumer goes on a pirate website and he sees a legitimate brand, he will say, oh, okay, this is a legitimate brand, great. So this pirate website may be fine, or, maybe this app is great, and they download content. Every time they download or they see that ad, the pirate website makes money. So first of all, that's the first negative impact. Second, it has a very, very bad, impact on the image of the brand. So if it's Samsung, it's on a pirate website. The pirate website also has other advertising, like I mentioned earlier, like adult advertising, etc. Right? So the brand image of Samsung therefore suffers because you're not in the right environment. Your ad should have not been there. So a lot of programs have been done, especially in the US, where the media and entertainment industry works with the advertising industry, and they do heavy research on identifying the rogue websites or the pirate websites. And there is a transparency list which is made. So proactively, the online advertisers know, okay, these websites are blocked and we will not allow any of our brand advertising to go there, thereby choking the revenue of the piracy website. So this is something that can be done at a very industry level as well. Domain name registries, like I said earlier, there was before certain legal developments in India, the MPA would work with NIXI, where we would inform NIXI about the pirate websites and ask them to check the KYC, know your customer details of these websites. Why is KYC required? So today, if you want to register a domain name, you would obviously be asked by NIXI for know your customer details. And most often, because there's so many thousands and thousands of sites which register, they put incorrect information. So we would research that, get back to NIXI. NIXI would send them notices. And invariably, we would see that most of the sites, which were pirate sites, they would never get back to NIXI when they were questioned about their know your customer details. And then they were blocked. Payment processors, which is basically MasterCard, PayPal, etc. Very, very important. Today, the minute you choke the pirate websites and tell payment processors to stop, processing information. Like I said earlier, if you all recollect, we spoke about a point where some of these pirate websites even ask consumers to upload illegal content, and in return for some money, or sometimes they would say, okay, we would give you some money, or you pay them money. Now all that has to be supported by a payment processor. How would you pay? So working with MasterCard, working with PayPal and legitimate payment processors is another way of stopping additional revenue flowing into the pirate websites. And these have been great industry collaborations that we've had over the years, in addition to law and in addition to support from enforcement. So when you look at copyright infringement, I just want you to know that it's really a holistic approach and not really a legal approach where you need to only understand the law. You really need to understand what the strategies across the world are. And here's a great example of that. This is an example of the Police Intellectual Property Crime Unit, which is based out of the City of London Police. This is a fantastic unit because it was specially created to stop piracy in England. And the unit, which is the Police Intellectual Property Crime Unit, works very closely with the MPA and the media industry in UK. So it's a coalition of advertising agencies, the MPA studios and other studios and stakeholders, including the English Premier League, where they collectively work on something called IWL. You'll see that here, I've star marked it. IWL is nothing but the infringing website list. So when you collate an infringing website list, you already know, okay, these are your rogue websites. These are vetted by the London Police, this particular unit. And then they start issuing notices against these sites. And because it comes from a legitimate, obviously an enforcement unit, most of these sites shut down really, really fast. And that's why when I say fall in mainstream adverts appearing on pirate websites, so what I mean by this is a lot of your, when I mentioned earlier here, online advertisers, many people would just advertise on these pirate websites unknowingly. So it really brought down those ads. And, as a result, these pirate sites were choked. And in addition to that, the police would also send them notices, so they would shut down. So it's a great cross-industry collaboration example. So borrowing from that example, I helped set up the Maharashtra Crime Digital Crime Unit. It's still functioning. It was set up in the year 2017, and it pretty much borrowed from the Police Intellectual Property Crime Unit, except that they did much more. So if you see, they would disrupt services, obviously, by sending notices. So minute we would send them particular websites, they would write to them. Mostly the sites would come down within 24 hours to 36 hours. They would work with advertising agencies, they would work with brands, they would tell them your advertising is appearing on these particular sites, and those ads were removed. So that would choke revenues. Outreach to central government, so they would work with the Ministry of Information Technology. There's a particular unit that caters to site blocking, and they would work with them. So there was a lot of work that this unit continues to do. And I believe that we should definitely encourage the formation of more units, if not make this unit the national unit in the country. So to conclude, protection of copyright. So copyright valuation of industries is a must. Now, today, you all are students, academics, and you all come from different fields. It's very important to understand what the valuation of copyright industries are in your field. So if it's a pharmaceutical, if it's pharma, then you should know how much the pharmaceutical companies are contributing to the economy of this nation. So for us, unfortunately, there's no national study. So one of the biggest things that we should do is start valuating. And when you put a particular value, then probably government, police enforcement, everybody can work together then on new strategies to combat this. And of course, controlling online piracy requires not only a nationwide enforcement mechanism, but also an awareness mechanism. And I'm very happy that IPTSC is not only giving a lot of awareness through their exams, but also conducting such workshops where you understand why this is important, why is copyright important. And moreover, you should feel motivated through such workshops to become a creator of your own. You don't need to necessarily make a film, but you can own an IP, because an IP lasts forever. Walt Disney is no more, but his company lasted forever, right? For a balanced framework, of course, like I mentioned, this is really to sum it up. We need, incentives. So it's very important, probably even at an academic level, if there are universities participating, engage with your professors, engage with your teachers and say, why don't we create an IP fund? If someone creates something new, even if it is, say, a device, it's a software, it's a film, right? Why can't we all be creators? There's definitely today a huge shift in the country towards startups. A lot of youngsters are starting their own businesses. There's a lot of government support, and there's, in my opinion, no better time for creating a balanced framework and enforcement mechanisms to protect not only just copyright, but any form of intellectual property. Thank you for listening. I think I made it on time, but I'm happy to answer questions.
So thanks, Ms. Lohita, for such a nice session on copyright and trademark infringement.
Yes, coming back to trademarks, because I never covered it. Let me distinguish between copyright and trademark. So trademark is I'm not going to get into legal definition of this, but simply anything which is a form, a color, a particular mark on a product. Very, very simple example being Coca-Cola, being Pepsi, right? The Apple symbol, anything which leaves a has a great uniqueness about it in shape, in form, in color, in logo, comprises an intellectual property called trademark. You do have trademark protection, but I urge IPTSC, we need more time for that, the trademark, because there are different provisions in the law. But you happy to take a session on that, but it would have extended time today.
So maybe next time, whenever we plan out this thing, maybe.
But I will encourage people. I think the biggest infringing of trademark is in the area of probably luxury goods. And that's because all of us want to look cool, and who doesn't want to look cool? Now, I was reading an article, which has actually got nothing to do with IPR, but I was reading an article on the pandemic and, how India today needs to have much stronger sustainable development goals. And anything that you do today, if you don't, first of all, I don't think you should buy something that you don't need. Everybody is headed towards a minimal way of life. But the worst part about most things that are infringed, say you buy sunglasses, like Gucci sunglasses, which are counterfeit, you're not getting the best quality lenses. You're using a substandard product, which could have a long-term impact on, probably your vision, etc. And again, you're feeding into a parallel crime economy. So I want to say that to you because it's very important. And like, it's not good to look cool and, wear counterfeit, but that's something that I want to say today. And I'm happy to take another session on really getting into the protection.
In fact, you raised the right question. In Delhi also, we see in Connaught Place, you can see the Louis Phillips of the world and Van Heusens of the world, Ray-Bans, freely available at $100-200. So that's how it is happening. It's happening openly. So let's hope that the police acts on it. In fact, while my
Yeah, and Rahul, I want to tell this group today because they're all the future thinkers. If you look at today, we just concluded the climate summit, right? The biggest message in the climate summit today was green, going green. It doesn't matter whether you're wearing, I'm not going to take names of brands. It doesn't matter if you're wearing X brand, which costs X lakhs, but it's good for you to look at probably wearing sneakers that's made out of sustainable material, where the company is using, green ways of going about it. The youth are going to be the revolution for the future. And when that happens, I think counterfeiting will automatically reduce, because why would you want to buy something which is made of plastic, which has zero recycle value? The value systems will bring that change in the future. Although we are talking about IP today, but I
absolutely
just
right.
that out there.
In fact, another great point which you you shared was this pirated version like websites. Now you see so many. So what people actually don't know, these are pirated websites,
Absolutely. Yeah.
pirate sites, and where they get branded, so-called branded wristwatches even. So people, why I'm also sharing here, because students are here and they should also understand that they shouldn't buy from these sites or these places. So with that, let me thank you so much, Ms. Lohita, for a wonderful session. And with this, we will move forward to the last session, which is with Mr. Vijay Kumar Shivpuje, who is an honorary advisor with IPTSE Academy, and he's also the director of Pratex Business Solutions. So he would
My
be talking
pleasure.
about.
Thank you. And all the best, Vijay.
Thank you.
Thanks. And he will be talking about introduction to patents and designs.
Yeah.
Mr. Shivpuje.
Yeah, thank you. Thank you so much, Rahulji, for the warm welcome. And so I am here for the last session. I know it's very difficult to have a session which is at the end, as well as it's difficult to have a session post lunch, I would say, because most of us had our food before or during this particular session. I'm not gonna take much of the time because we have actually kind of elaborative discussion on the I would say different types of IPs, and the topic that has been allotted to me is about patents and design. These are the rather, I would say, the topics that I have been practicing since last almost 16 years in the industry, as well as a independent practitioner per se. So just a quick check if my screen is visible. Yes, Rahulji?
Yes, it's visible.
Okay, great. Thank you. So I must take this opportunity to thank ICC, Indian Patent Office, Rahulji, as well as Sri Ram Swarup Memorial University, Lucknow. I had this wonderful opportunity to visit the university couple of 3 years back, rather, doing a similar program for intellectual property rights awareness, and at that point of time had really good memories as such for the university. I'm very much thankful to Dr. E.K. Singh, the Vice Chancellor, Dr. Ajay Prakash ji, Dr. Prachi, who has been coordinating for this particular event, and Dr. Balveer Singh for providing this opportunity to have this entire program today. Actually, I'm gonna discuss about patents and design. I've been practicing this, what Rahulji mentioned. Beyond that, I've been associated with AICTE, Startup India, Atal Tinkering Lab, as well as Indian Patent Office in various capacities. To be honest, I've been working a lot with students, faculties, academic institutions, autonomous institutions, universities across the sector. I belong to pharmaceutical industry. I'm a master's in pharmacy, but then I'm catering the needs of almost every kind of industry or every kind of institution, basically. I'm going to speak about very fundamental basics about patents and design and the kind of examples that we have for patents and designs actually. So when we think of patents, of course, these are applicable to research related industries, those industries which are an industry like telecom, an industry like pharmaceuticals, chemicals, biotechnology, agriculture, automobiles, जहाँ पे भी research हो रहा है, all these industries are dependent on the kind of IP which is called as a patent. Now, for the research inventions, we have patents, and then there are basic criteria. What was also discussed by Mr. Vikas Sharma, the Deputy Controller at Indian Patent Office. Novelty, non-obviousness, and industrial applicability. Let me be very specific about today's audience, and what I have done in my session is I have got some inventions which are patented from the agricultural or pharmaceutical industry. I would call it as herbal patents, basically, because there are a lot of misconceptions about herbal patenting as such. So I'll go through those examples as well. But before that, I'll take you through very basic. These are some of the questions that have been asked to me again and again through all my sessions, basically. And I have just collated them, and I'll try to answer it in the form of simple statements, basically. So when should I file a patent application? The very first criteria for filing a patent application, if at all you are looking forward to, is when you have an idea in your mind. It is not necessary that you have executed or worked in the lab for that particular product to file a patent. Indian Patent Office or globally any patent office gives you an opportunity to file a patent the moment you have an idea in your mind. You don't need to execute it. You have 1 year time to execute it, and thereafter you can actually file the complete application. Now, why should I file patent application? Of course, the general answer to this is for the protection of your invention. As far as the typical academic institutions or the universities like SRM are concerned, at that point of time, the practical answers that we have got for filing the patent beyond protecting the inventions are, it would definitely help for the university or the institution for their rankings, as well as it's gonna help you for your accreditations as well. Now, if you look at national education policy that has come up recently, the focus has been shifting from teaching to innovation and entrepreneurship. And IP is basically a link between that innovation and entrepreneurship. That's the reason it is very essential that if you have a research, you should file a patent application. The students get benefited. Those who are working on that, the master students or researchers, they get benefited because of that. Now, what data do I need to file a patent application? As I said, you don't need to have any data upfront. Of course, you need to execute and then generate the data with respect to what you are claiming. Basically, based on that, you can actually have the data generated within 1 year time. But upfront, if you have a broader concept and if you feel like, let us think of a product, let us say, which is an insecticide or pesticide. Now, you know that this particular combination, which is from let us say herbal origin or natural origin, can definitely work as an insecticide or pesticide. In that case, you can simply file an application without any data or with a hypothetical example as well. Later on, within 1 year, definitely you can actually get the data generated, but this data depends on what you are claiming. Remember, for having your thesis, master's or PhD thesis or a undergrad project, at that point of time, you may need all the data to show. But for patent filing purpose, the data that is required is comparatively very less, and it would depend on what kind of invention you have got. Another question very commonly asked by the academicians or the students rather, shall we take a help of a patent agent for patent filing? Now, the answer to this is tricky, and of course, I'm a patent agent. I would always say that you take a help of a patent agent actually. But then, to be honest, patent is just not a technical document. It's a techno-legal document. You may be an expert in the technology or technical domain. In pharmaceutical technology, you understand everything. In agricultural technology, you understand everything. You are an expert in that. Absolutely fine. But patent, like a research paper, is not a technical document. It's a techno-legal document, basically. So that legal part is something what is more important to understand. And as a faculty or as a researcher, you may not be aware of that. That's the reason you should take a help of a patent agent. Another question, very common question, can I publish my research before or after patent filing? Before patent filing, it is not allowed to publish the research, present the research in any conference, put it on the YouTube, put it on the Facebook, Instagram, LinkedIn, putting it on a let's say in a particular conference, in a newspaper as well. That is not allowed. You cannot publish because it would kill the novelty for your invention. So ensure that you cannot publish, you should not publish your research before patent filing. Now, what after patent filing? Once I file the patent today, tomorrow you can publish. There is no concern for that. Now, can I commercialize my invention after patent filing? The concept is that the moment you file, the product can be in the public domain. So you have legally protected it. How much is the cost for patent filing? The official cost for patent filing has been reduced now for academic institutions. So normal cost for just patent filing at IPO is just 1600 rupees for an academic institution. For drafting, and of course the professional service charges are separate, but then the official cost is really very less now. The cost was really very high actually, because the filing cost was around 8,000 and request for examination around 22,000. That was the cost earlier, but now this has been reduced to 1,600 and 4,000. That's the maximum cost you have to pay to the patent office. Beyond that, the cost would be for the agent or the attorney. Can I file patent application without telling my institute or guide? Now, a very interesting question, because I had one student who came to me and उसने मुझे बोला, sir मुझे patent file करना है. I said, fine, you send me a mail, share your details. But then उसका एक condition था, sir मैं ना अपने guide का नाम उसमें include नहीं करना चाहती. I was a bit surprised. Why that? Why do you want to do that? She had her own reasons, but so there is a concept called intellectual property rights policy. So just like we have attendance policy at our institution, just like we have a different kind of policies, dress code, or so any kind of policy per se that we have at academic institution. So MHRD, so now what we call as a Ministry of Education, they came up with a model IPR policy few years back, and that is something which you should have at your academic institution or university. If the institution, the university, if you don't have the IPR policy in place, create a policy. That's my request, because all these problems, if your researcher moves out, or if you are one of the faculties moves out tomorrow and they are taking the know-how or the research from your institution to some other, they are filing the patent. To avoid this, you need to have IPR policy in place. In the absence of IPR policy, if your student moves out and if he or she files a patent, legally you cannot stop them from doing that. Okay, because anyway you would come to know only after the application is published, so it would already be quite late, I would say. Can someone else file patent application of my invention? India में सब चीजें होता है, unfortunately. We are sharing the labs. My research or my invention is available on a system which is shared by 10 other people as well. That point of time, a possibility hai. Again, to avoid this, you need to have IP research, IPR policy per se. Because once I file a patent with Indian Patent Office, they would never ask me, where did you carry out the invention? They would never ask me for the sample or proof for filing of the carrying out the experiment as well. So it is always essential that you have because ऐसे cases हुए हैं. Of course, there is a way to legally tackle it if someone else files my invention as a patent application. Okay. Now, let me go to the next set of questions, which are about filing to grant. Some part of it is already been covered by Vikashji actually in his session. But then when does the application get published? Patent application usually gets published after 18 months. There is an expedited or early publication as well, which is available, wherein your application can get published within a week or two as well in the early publication. How much time does it take to get it granted? Usually 3 to 4 years in the average, like I would say, process. That's what is required. Now, we have got expedited examination process under which we got a patent granted within 8 months time as well. But only disadvantage of expedited examination is that you have to bear the entire cost within 1 year or 8 months. When you go in a normal process, this cost is scattered over 3 or 4 years. And the expedited examination costing is a bit 10-15% higher compared to the normal examination. Is publication of application, does that assure you grant? No, not at all. Every application automatically gets published. If it gets published, not necessary that it would get granted as well. What is the cost after filing till grant? I think I shouldn't cover this because it's a public forum and this is a program by Patent Office. But then those who are interested can get in touch separately as well. Can I commercialize my invention after that? Absolutely. But remember that I think this was also covered by Dr. Sheetal in her session, that patents are negative rights. So commercialization has nothing to do with actually the getting a patent granted. These are independent activities basically. Now, one of the most common questions that have been coming to me is nowadays is, would I be Funsuk Wangdu? If you remember Funsuk Wangdu, the character in 3 Idiots, once patent gets granted, no, it's not your invention or a patent granted that would be commercialized. It would be the product. It would be the product that would be actually commercialized. आपके product को अगर commercializable value है, then only someone would come to you for licensing. आपके पास patent है करके, no one is going to come to you and give you those $millions and बहुत सारे पैसे दे के आपका patent कोई नहीं खरीदने वाला. It is the product which is protected by the patent that is more important, right? Now, what is the difference between a design and patent? I'll cover this here. Now, I just want to cover few parts related to herbal patenting because there are certain misconceptions, be it a pharmaceutical side or be it agriculture side. To be honest, herbals are patentable. So although in India we don't have traditional knowledge that can be patented, but herbal products can be patentable. How are they patentable? Now look at this kind of example. If you put it in the percentages, so like for example, leaf extract of Pergularia demia, 30 to 40% weight by volume. So if you put it in the formulation part, okay, end product, then it is patentable. But if I go and try to patent Pergularia damia itself as a herb, no, it's not patentable. Okay, if you put it in the form of quantities, like 800 gram to 1.2 kg of maize. अब ये herbal biscuit है जिसमें maize, wheat, soybean और दालिया है. A simple nutraceutical product, right? But then the quantities made it patentable. If you have weight ratios, look at this actually. Herbal cola, herb ka combination not patentable, but herbal cola patentable. Look at the patent numbers as well. These are all Indian patents granted, okay, for the herbals. Excipients, those who are from the pharmaceutical or agriculture stream, they would understand this term. Excipients, basically, if you put herb with an excipient, yes, it is patentable. Again, in the form of formulation, that is tablet. Herein, process for preparing a composition is also patentable. Now look at this dosage form. A soap, herbal soap, is patentable. If I go for a plant directly for patenting, it is not patentable basically. Processing in composition like stabilization of serratiopeptidates, something which is also patentable. So herbals are definitely patentable. In fact, there can be an entire one long session on herbal patenting itself. But then why I chose herbal patenting here? Because as Dr. Prachi mentioned, we have pharma and agriculture people, and I realized this is one thing which would be common for both the streams basically. Then let me go to another type of IP, that is industrial design. So I think this was also covered in Miss Lohita's session. Actually, she mentioned about designs, the external appearance. Even Dr. Sheetal covered this. The industrial design basically recognizes the aesthetic look, external appearance of a product. It can be a shape, a config. It's never about the use or utility of the product. How it looks. Just for example, we speak of jewelry. Okay, we speak of jewelry. In that case, jewelry has certain design, and that design can be protected here. Now, for me as an individual, when I see so many jewelries in front of me, and if I go to buy, मैं अपनी wife को यही बोलता हूँ, आप कुछ भी खरीदो उसमें तो गोल्ड ही तो है या सिल्वर है या डायमंड्स है, राइट? गोल्ड ही तो है इसमें क्या देखना है इतना? But how it looks basically. So jewelry industry is dependent on industrial design. But then But then, as I said, industrial design protects the external appearance. How does the product look like? What is the finished state appeal, and how is it judged by the eye? हम कैसे देखते हैं उस product को basically. That's what is protected under industrial design. But it's just not about the, I would say, the jewelry design industry. We have a lot of designs protected in the agriculture sector as well. Look at these examples. Now I have got this shaft cutting machine or shaft cutter. These are coming from different people. So the second one is from Shulini University, and Malwa Agricultural Equipments coming from Punjab. So shaft cutting machine, basically, that's what they have protected under design. Now this is another Sandeep Deshmukh, bionic blade cage wheel for agricultural tiller. जो भी आप agriculture में instruments बना रहे हो ना, वो सारे designs के under protect हो सकते हैं. Let me tell you one advantage of design is design gets granted within a year. 3 या 6 महीने में भी कभी-कभी design grant होता है. First thing, cost, even the IP office cost is really very less, 1,000 rupees. That's it, final cost. And at the max, आपका FER reply और hearing भी अगर होता है तो the cost won't go beyond 12 to 15,000. 15,000 में आपको ये design grant हो सकता है. Then we have laterite soil pulverizer, another instrument which is used in agriculture. Maize dehusker, maize को dehusk करने के लिए. Tree climbing machine. These are some of the inventions coming from engineering or with the help of agriculture sector. Basically, these can be very easily protected under design. Now, the beauty of this is it's just the external appearance of the product that is protected. It may be multi-spindle nut runner or washing machine for agricultural crops. A wonderful concept, I would say. Now, there is an innovation coming, and so when should you protect your invention under design? If the utility of the product is dependent on the design or external appearance. In that case, you should protect it under industrial design. But as I said, as an academic institution, if you are really looking forward to file some IP, then design is the easiest option, especially for the agriculture. Not only for agriculture, even for farm. I'll tell you some examples. Now, this is another floating aid for aquatic agriculture or portable mineral block dispenser. Like, kind of examples that we see typically into agriculture. Now I have got a invention, ultraviolet light equipped food container which also has a UV light. Okay, so that is helping in case of sanitizing that food product, basically. Asthma wristband coming from the medical devices side. Basically, these products are protected. Then we have UV lamp as a disinfectant or color coded label, pharmaceutical product hai. This comes from Sun Pharmaceuticals. This label is protected under design. So all this can be actually protected. So anything that is unique in terms of its aesthetic look can be protected. Why I'm covering patent, of course, patent are, as I said, are related to inventions, but design also provide you a lot of advantages, typically as an academic institution. Now, just to compare, patent is for product or processes. Design is only for product shape. It's never for the process. आपको design में pictures देने पड़ते हैं. Okay, aesthetic appearance. That's what is protected. In patent, it's utility or use of that particular product. Patent protection is for 20 years and design protection is for 10 years. Of course, both of them provide you monopoly right. Okay, there is no extension in case of patent. In case of design, we have 5 years of extension, 10 plus 5, that is feasible under the Indian Designs Act. Actually, third party use अगर करते हैं तो उसे patent के केस में infringement बोलते हैं, design के केस में piracy बोलते हैं. So what Lohita was speaking about, the piracy, that's exactly the same thing, like, in case of copyright. Protection is first to file. If I file first, I would get the protection. and licensing opportunities are always possible. So if you have a patent or a design, definitely if you don't have the capability to commercialize it, that can be licensed out. So you can be that Funsuk Wangdu, to be honest, if you remember the movie Three Idiots. So in Three Idiot movie, we had Funsuk Wangdu who had some inventions, and someone like, Chatur Ramlingam wanted to commercialize it basically. So he comes down to Funsuk Wangdu and gets actually the inventions so that he can actually commercialize it. Okay. So to be honest, I just wanted to be very crisp, so that just to provide you an overview of patents and designs. I understand that the patent part was already covered in Vikas session basically, but then so if there are any queries, I'm done with my session. I would love to take any queries if there are any, and for sure, just if you have any queries, you can also get in touch with me on my direct email address or phone number, or get connected with me on LinkedIn as well. So thank you so much, everyone. Thank you so much, Rahulji, for giving this opportunity to present here. Would be more than happy to take if there are any questions.
Yeah. Thank you, Mr. Shiv Puja, for the nice session. I believe it would have been very, very important for all the students out here who have gone through the grilling sessions since morning. Yes, agree enough?
Absolutely, sir. It was a lovely session.
What you can do is, any questions coming out after this program, you can collate it and send it to Mr. Shipuje and deal it accordingly. So we are at the end of the today's sessions. So I would like to formally thank the Intellectual Property Office India, Mr. Vikas Sharma, and the Dr. Prachi Bhargava also, from Shri Ram Swarup Memorial University. All the students out here, all the speakers, Dr. Sheetal Chopra, Mr. Vikas Sharma, Ms. Rohita Sujit, Mr. Vijay Kumar Shivpuje, Arnav, and every